I would like to welcome you all in my capacity as the chairman of the Council of the Hague Conference of Private International Law to this day of celebration here at the Hague Peace Palace premises. Today here it is not for me to talk, but rather the others, and it is therefore that after presenting the persons here on the podium, I will give the word and the floor to others. Here at the podium, on my left-hand side, is Her Excellency Susana Ruiz Cerruti, and Director General for Consular Affairs and Operational Management and Deputy Secretary General of the Ministry of Foreign Affairs, Ms. Monique van Dalen. And then on my right-hand side, His Excellency Rimsky-Yuen Going. I would like to welcome you all. I would like to welcome you all, Your Excellencies, ladies and gentlemen, to this day of celebration of 120 years of the Hague Conference. And with that, and without more from my side, I would like to give the floor to Ms. Monique van Dalen, please.
Excellencies, Mr. Secretary General, ladies and gentlemen. Frans Timmermans, the Minister of Foreign Affairs, is unfortunately not able here to open the celebration of the 120th anniversary of the Hague Conference. He has asked me to address you in his place. The reason that Mr. Timmermans cannot be present is that he is accompanying Russian President Vladimir Putin, who is visiting the Netherlands this afternoon. Voilà un de ces nombreux moments où les chemins de l'histoire se croisent à nouveau. Je vous raconterai pourquoi un peu plus tard. In 1883, the first Hague Conference on Private International Law took place in The Hague under the leadership of Dutchman Tobias Asser. Asser believed that legal conflicts between different national systems could best be solved by international conferences, which would agree common solutions to be implemented by each participating nation. C'est à lui et à tous ses collègues venus du monde entier, conscients de l'importance de cette initiative, que nous devons de célébrer aujourd'hui le 120e anniversaire de la conférence de La Haye. The choice of The Hague as the site of this international conference had major positive consequences for the Netherlands. It led to The Hague being chosen as the site for the peace conferences of 1899 and 1907. Interestingly, to return to the Russian connection, the Russian Tsar Nicholas II chose The Hague at the suggestion of his legal advisor, Fedor de Martens, who had attended the first two sessions of the Hague Conference on Private International Law. The peace conferences produced international agreements on peaceful settlement of disputes. This led to the establishment of the Permanent Court of Arbitration, for which the Peace Palace was first built. Later, the UN's International Court of Justice would make it its home here as well. In August of this year, we will celebrate the 100th anniversary of the opening of the Peace Palace. Tobias Asser's idea of finding mutually acceptable solutions to conflicts is still central to the work of the Hague Conference today. The conference's efforts to promote the international legal order and the rule of law worldwide reflect this same thinking. But simply devising new rules is no longer a sufficient means to this end. Today, the Center for Judicial Studies and Technical Assistance allows the Hague Conference to help its members build their national legal expertise and capacity. This facilitates the implementation of major Hague Conventions and so strengthens the international legal order. En tant que directrice générale des affaires consulaires, je suis à même de donner quelques exemples où se croise le travail de la conférence de La Haye et les pratiques quotidiennes du ministère néerlandais des Affaires étrangères. Take the Apostille Convention. The convention abolishing the requirements of legalization of foreign public documents, which is crucial for us. Since 1965, this convention has made moving to another country easier for the nationals of dozens of states. By replacing the legalization of a whole series of official documents with one stamp, the apostille. Children's interests also play a central role in the Hague Conventions, notably in matters of adoption and of child abduction. In principle, adoption from countries that are party to the Hague Inter-Country Adoption Convention is automatically recognized in the Netherlands. This means that procedures in these countries are generally quicker and more reliable, certainly compared to what happens when a child is adopted from a country that is not party to the convention. Those adoptions are not automatically recognized. This can lead to complex, time-consuming, and sometimes distressing situations. So it is in all our interests for as many countries as possible to accede to this convention. Since 1990, the Netherlands has also been party to the Convention on the civil aspects of international child abduction. We always treat cases of child abduction the same way, whether countries are party to the Convention or not. At the request of the Netherlands Central Authority, my ministry acts as a mediator in cases of child abduction to countries that are not party to the Convention, and occasionally even to countries that are. There seems to be a felt need for more exchanges of experience among the different state parties about the procedures to be followed. In the interest of the children, it is vital that time limits laid down in the Convention be respected as much as possible. Les Pays-Bas soutiennent pleinement les efforts de la Conférence de la Haye en matière de mise en œuvre des conventions. C'est un travail de longue haleine qui demande la coopération des pays membres ainsi que l'implication de sa participation de chacun. C'est en joignant nos efforts que nous verrons vraiment notre travail porter ses fruits. And in the work that lies ahead for the conference, it can count on the continued support of the Netherlands as its host country. Later this year, we will join together to mark the departure on the 1st of July of Dutchman Hans van Loon as Secretary General of the conference after years of hard work and great dedication. We are glad that a successful open hiring process has led to the appointment of a worthy successor, the current Deputy Secretary General Christophe Bernasconi. I can assure you that the Netherlands' support will be ongoing. Pour conclure, permettez-moi de vous transmettre le message de félicitations personnelles de Frans Timmermans à la conférence de la Haye à l'occasion de son anniversaire. Quote, on behalf of the Dutch government, it is my pleasure to congratulate the Council on General Affairs and Policy, the Permanent Bureau, and the staff of the Hague Conference on Private International Law on their many achievements during the organization's first 120 years. Thanks to all your valuable and dedicated work and the support of the member states, the Hague Conference has become a key global player in international commercial and civil matters. I wish you every success in achieving the goals you have set for the next 120 years. Thank you.
Thank you very much, Madam Dahlen, for these words of introduction. And indeed, thank you on behalf of the Council and the members of the conference to the government of the Netherlands for this support that you have provided for the conference for now 120 years, and also a support that will be continuing, you promised, for the next 120 years. Thank you very much. It is of course indispensable for the conference and for any organization of this sort that there is a full commitment from the host state to provide everything that needs to be provided for the functioning of the organization. That certainly is what has happened in the case of the Hague Conference and the government of the Netherlands. Thank you for that. As Madame Dahlen noted, and as we all know, the Hague Conference started out as a European organization, a regional organization. It has grown and become very much a global player with increasing, accelerating speed during the last 10-20 years. And it is this side of things that is to be highlighted now in the next two speeches that will be provided by our keynote speakers on the impact of the Hague Conference in two important regions of our world. And in relation to the Latin American region, I would now like to give the floor to Her Excellency Susana Ruiz Cerruti. The floor is yours, please.
Madame la Secrétaire Générale Adjointe du Ministère des Affaires étrangères, Monsieur le Secrétaire à la Justice de Hong Kong, Monsieur le Secrétaire Général de la Conférence, Mesdames et Messieurs les représentants des États membres de la Conférence, Mesdames et Messieurs. J'aimerais tout d'abord féliciter les membres du Bureau permanent et tous les fonctionnaires des États qui sont liés aux travaux de la Conférence et qui ont su, grâce à leur engagement permanent, préserver fortement et pleinement le dynamisme de cette organisation. Je souhaiterais également remercier l'occasion qui m'est donnée de pouvoir partager avec vous certains des aspects saillants concernant la présence de la conférence en Amérique latine. En effet, nous n'avons pas souvent l'honneur de participer à une cérémonie commémorant les 120 années d'existence d'un organisme international. Dans le cas de la conférence, son origine, son histoire et sa situation actuelle lui confèrent un lieu spécial parmi les acteurs de la communauté internationale. Examiner les plus de 100 années d'histoire de la conférence de la Haye, c'est aussi reconnaître les chemins jalonnés de succès que ses membres ont parcouru pour qu'elle soit au cœur du développement du droit international privé, en œuvrant en vue de son unification à vocation universelle et pour faciliter la vie des millions de ressortissants des États qui la composent. Le XXe siècle a été défini comme le siècle de la mondialisation, des mouvements migratoires massifs, où les rapports entre les personnes et les familles sont passés à l'échelle internationale. Un rythme sans précédent dans l'histoire de l'humanité, en soumettant ces liens aux règlements juridiques les plus variés. Le défi des États au XXe siècle, qui s'applique encore plus au XXIe, a été de garantir une plus grande sécurité juridique et d'apporter des solutions justes et équitables à des situations sui generis occasionnées par les mouvements internationaux des individus. La coopération et la codification du droit international privé se sont avérées être des outils adaptés pour atteindre ces objectifs. Et la conférence de la Haye en particulier est devenue, au fil de ses 120e années d'existence, un forum qui a réussi à unifier les règles du droit international privé dans le domaine de la coopération judiciaire et administrative internationale, de la protection des enfants et de la famille, et sur certaines questions liées au droit commercial. À cet égard, c'est un honneur pour moi d'avoir aujourd'hui la possibilité de me référer aux travaux de l'organisation en Amérique latine, l'une des premières régions au monde à avoir compris les besoins de travailler entre États pour garantir une harmonisation efficace des règles du droit international privé. Le traité de Montevideo et les conférences spécialisées interaméricaines du droit international privé, organisées dans le cadre de l'Organisation des États américains, sont autant de contributions fondamentales des pays américains au droit international privé, y compris les dispositions qui ont permis des avancées scientifiques incontestables. Ces expériences ont démontré de manière catégorique que lorsque les activités sont liées les unes aux autres par des liens culturels, géographiques et linguistiques spéciaux, elles ont plus de chances au niveau régional d'être couronnées de succès. À ce propos, en 2005, le programme spécial de la Conférence pour les États latino-américains a été créé afin de promouvoir la participation des pays de la région à ces travaux. M. Ignacio Goicoechea, ancien membre de l'autorité centrale argentine, créée au terme de la Convention de la Haye de 1980, a été nommé collaborateur juridique de liaison pour l'Amérique latine, afin de répondre à la demande croissante de formations spécialisées et d'orientation de la part des gouvernements sur l'application et la mise en œuvre des instruments de la conférence. Le premier succès du programme a mis en évidence la nécessité et la pertinence de créer une extension du bureau permanent dans la région. Et c'est ainsi qu'est né le bureau régional pour l'Amérique latine, dont le siège se trouve à Buenos Aires. La principale fonction du bureau régional est d'augmenter la visibilité dans la région de la conférence et des conventions signées sous sa houlette. Le fait que la langue de travail soit l'espagnol permet d'avoir un accès direct aux acteurs du secteur public et privé des pays latino-américains, en apportant une assistance technique et en contribuant à l'application appropriée et au fonctionnement des conventions de la Haye. De même, son existence a accru la coopération intrarégionale en rapprochant de nouveaux pays aux travaux de la conférence. Depuis sa création en 2005, 3 pays, le Paraguay, l'Équateur et le Costa Rica, sont devenus membres de la conférence, tandis qu'un 4e pays, la Colombie, va d'ici peu faire de même. De plus, 11 ratifications latino-américaines à différentes conventions de la Haye ont été reçues. Il est également important de souligner que le bureau régional a renforcé les rapports entre la conférence et d'autres organisations internationales et régionales ayant une forte présence en Amérique latine, en participant à leurs réunions et en organisant des événements conjoints. En particulier, avec les Fonds des Nations Unies pour l'enfance, l'Organisation des États américains que je viens de citer, l'Institut interaméricain de l'enfant et de l'adolescent, les comités juridiques interaméricains, le Mercosur, l'Agence espagnole pour la coopération internationale au développement, la Cour centra-américaine de justice, la Conférence des ministres de la justice des pays ibéro-américains, le réseau ibéro-américain de coopération juridique internationale, le réseau latino-américain pour le placement en famille d'accueil et l'Association internationale du Mercosur des juges de l'enfance et de la jeunesse. Par ailleurs, sur le plan académique, le bureau a œuvré pour l'échange régional en créant des contacts et en menant des programmes en collaboration avec de prestigieux établissements éducatifs de la région, comme l'Université catholique de Rio de Janeiro, l'Université nationale autonome du Mexique, l'Université catholique du Pérou, l'Université du Chili et l'Université de Buenos Aires. De même, il maintient une relation fluide avec des organisations académiques comme l'Association américaine du droit international privé, les centres d'études de droit international privé, et les centres d'études de droit, d'économie et de politique du Paraguay, de recherche et d'enseignement économique du Mexique, l'Académie mexicaine de droit privé et comparé et l'Association argentine de droit international. Concernant les travaux des organes internes de la conférence, le Bureau pour l'Amérique latine facilite la participation des délégués aux réunions régionales et internationales, oriente les délégués et les experts pour obtenir des informations pertinentes et encourage les dialogues régionaux à travers des conférences téléphoniques, des réunions régionales et de la préparation de propositions conjointes et de documents de travail pour des réunions globales. La participation active des délégués d'Amérique latine dans les commissions spéciales récemment créées a augmenté de manière significative et a contribué au bon déroulement de ces réunions en apportant une vision différente au travail de l'organisation. Il convient de signaler que le travail mené par la conférence en Amérique latine a été possible grâce non seulement au soutien du gouvernement argentin, qui a mis à disposition un espace et a assumé les frais de fonctionnement du bureau, mais aussi aux généreuses contributions volontaires d'autres membres de l'organisation qui ont permis de mettre en œuvre des projets d'assistance technique dans la région, à savoir les États-Unis, l'Espagne, les Pays-Bas, le Canada et l'Allemagne. Le succès du programme pour l'Amérique latine a été confirmé par la récente ouverture du bureau régional pour l'Asie-Pacifique à Hong Kong, à qui nous souhaitons, au nom de la République argentine, le plus grand succès. Il faut reconnaître à l'heure actuelle le succès des projets visant à unifier les normes de droit international privé, que ces succès reposent non seulement sur le travail régional, mais aussi sur l'universalité de cet exercice. Ce point de vue a modifié la vision traditionnelle qu'avaient les forats internationaux, dont la conférence, qui a fait preuve d'une grande capacité d'adaptation aux nouveaux défis. C'est pourquoi j'aimerais conclure ces quelques mots avec une spéciale adresse au secrétaire général Van Loon, qui va bientôt quitter son poste à la conférence. Depuis 1996, grâce à son remarquable leadership, l'organisation a connu une incroyable étape de croissance et d'universalité. Je souhaiterais, au nom de l'Argentine, le remercier de tout cœur pour son travail et son engagement. Nous espérons pouvoir continuer à compter sur ces précieux conseils. Il ne me reste plus qu'à souhaiter à l'organisation encore 120 années de plus de travail intense et fructueux. Merci beaucoup.
Yes, thank you very much, Your Excellency, on this speech on the focus of which was on Latin America. And now we turn into another important region, that is the region of Asia Pacific. And I would like to give the floor to His Excellency Rimsky-Yuen Kwok Keung, Secretary for Justice in Hong Kong. The floor is yours, please.
Secretary General Mr. Van Loon, Your Excellencies, distinguished guests, ladies and gentlemen, it is my great honor to join you on this special occasion for celebrating the 120th anniversary of the Hague Conference on Private International Law, and also to have this opportunity to briefly share with you the key development and outreach of the Hague Conference in the Asia-Pacific region. Law, whether domestic, regional, or international, exists to serve the human community. As human societies change, their laws evolve. Over the past 120 years, the world has undergone dramatic changes. Back in 1893, when the Hague Conference held its first meeting, no one could possibly anticipate the invention of the Internet, nor foresee the process of globalization and regional integration that has taken place in the past few decades. Notwithstanding the huge changes to the scene in which private international law operates, the Hague Conference has grown in such strength and size, as well as extended its influence in numerous areas of human activities. Indeed, the history of the Hague Conference vividly illustrates the close relationship between the development of private international law and the changes our world has experienced. In the 1870s, the pioneers of the Hague Conference were the first generation of lawyers faced with the impact of the industrial era, especially the dramatic intensification of international communications. This sets the scene for the Hague Conference first meeting in 1893. Although the initial key participants were primarily the continental or civil law jurisdictions from Europe, it soon embraced both civil and common law jurisdictions, especially after the coming into force of the Statutes of the Hague Conference in 1955. In the 1980s and 1990s, more states, including Australia, the People's Republic of China, PRC, and several Latin American countries joined the Hague Conference. On the turn of the millennium, the work of the Hague Conference was visibly extended to cover jurisdictions in the Asia-Pacific region on top of those in Latin America and other parts of the world. Apart from the setting up of its first regional office in Latin America in 2005, the Hague Conference at around the same time experienced a marked increase of the involvement of Asia-Pacific countries. Sri Lanka, Malaysia, New Zealand, India, and the Philippines all became members of the Hague Conference during the period from 2001 to 2010. Further, the 4 Asia-Pacific regional conferences held in Malaysia, Australia, the Hong Kong Special Administrative Region of the PRC, and the Philippines, respectively, in 2005, 2007, 2008, and 2011, witnessed strong participation and keen interest in the work of the Hague Conference amongst both members and non-members within the Asia-Pacific region. As of now, the Hague Conference has become a global forum truly representative of the international community in all important aspects concerning private international law. The Asia-Pacific region is a very vibrant and dynamic region. Jurisdictions within the Asia-Pacific region provide strong momentum for regional and global economic growth. Take the year 2011 as an example. The total GDP of the 10 member states of the Hague Conference in the Asia-Pacific region accounted for around 26.45% of the world's total GDP. Whilst geographically close, jurisdictions within the Asia-Pacific region are very diverse in terms of history, culture, religion, languages, economies, as well as legal system and legal tradition. Within the region, there are both civil and common law jurisdictions. There are jurisdictions whose culture are primarily Western, but also jurisdictions which are cosmopolitan and international. The economic development and immense diversity of the Asia-Pacific region make it even more important to have a coordinated and harmonized network of private international law. Indeed, the greater the diversity, the stronger the need to have a common framework, such as the one provided by Hague Conventions. Such a network would benefit not only the Pacific region, but the world as a whole. The establishment of the Asia-Pacific Regional Office in Hong Kong is a logical and desirable development in the history of the Hague Conference. It is a natural result of globalization, regional integration, as well as the increasingly important role played by Asia-Pacific jurisdictions in global economy, international trade, and other aspects of human activities. A key objective of the Asia-Pacific Regional Office is to promote the Hague Conference and its convention by increasing awareness of the value of the membership of the Hague Conference and the usefulness of Hague Conventions to the region, with a will to attracting more states in the region to become members of the Hague Conference and state parties to Hague Conventions. Put shortly, The Asia-Pacific Regional Office will assist the Hague Conference in strategically positioning itself in the world map so as to further enhance its presence and influence in the region, which in turn will facilitate the achievement of the ultimate aim of progressive harmonization of private international. Since 1998, the representatives from Hong Kong have been participating actively in the meetings of the Hague Conference as part of the Chinese delegation. Hong Kong is most honored and privileged to be chosen as the place in which to establish the Asia-Pacific Regional. Apart from being grateful for the support provided by the Central People's Government of the PRC, especially the Ministry of Foreign Affairs, may I take this opportunity to again express my gratitude to the Permanent Bureau of the Hague Conference as well as its members for the trust and confidence reposed in Hong Kong. As the Secretary for Justice of Hong Kong, I can assure all of you that Hong Kong is indeed the right place for the regional office, and Hong Kong will do her very best to facilitate the work of the Hague Conference. Hong Kong has for years been and will remain a truly cosmopolitan and international city. Her status as an international financial and commercial center, as well as regional logistic hub, hardly requires further elaboration. Equally clear is the fact that Hong Kong is the main gateway to mainland China, one of the key powerhouses of the world's economic engine. Further, and very importantly, Hong Kong is internationally well known for her firm commitment to the rule of law and her truly independent judiciary. By reason of the one country, two systems concept and the provisions in our basic law, Hong Kong continues to maintain our common law legal system after the reunification in 1997. The Heritage Foundation has for 19 consecutive years ranked Hong Kong as the freest economy in the world. In the recent report entitled Global Opportunity Index, Attracting Foreign Investment, published by the Milken Institute in March this year, Hong Kong came first amongst the 98 jurisdictions included in the survey. Apart from our economic policy, the rule of law and efficiency of our legal system play an important role to enable Hong Kong to achieve these and other favorable rankings by independent international institutions. As confirmed in our Chief Executive's latest policy address, it is our government's policy to enhance Hong Kong's status as a regional hub for legal and dispute resolution services in the Asia-Pacific region. With our top-quality legal profession comprising both local and international law firms and advocates, our truly independent judiciary, and our modern legal infrastructure, Hong Kong is well placed to be the regional hub for legal services. Such policy and attributes of Hong Kong would be of considerable value in assisting the Asia-Pacific Regional Office in the performance of its function and fulfillment of its objective. As has been repeatedly pointed out, the success of the Hague Conference should not be measured solely by reference to the number of member states signing or ratifying Hague Conventions. The benefits and impact brought about by the Hague Conference go well beyond the formal adoption or implementation of Hague Conventions. As noted earlier, there exist vast diversities amongst the jurisdictions within the Asia-Pacific region. Hague Conventions, which are intended to bridge different cultures and legal traditions, are accordingly very useful in providing a common framework for cooperation both for the states in the region and between those states within and those outside the region. The increased membership base in the region will bring about wider representation of a diverse range of legal traditions to the Hague Conference and help develop new instruments better adapted to meet the needs of the Asia-Pacific region by involving the states in the region more actively in the development of new instruments and more generally in the work of the Hague Conference. Increasing the number of state parties to the Hague Conventions in the Asia-Pacific region will provide additional opportunity for enhancing certainty and predictability of cross-border private, commercial, and financial transactions and relationships, promoting judicial and administrative cooperation, and reinforcing protection of children and other vulnerable persons in transborder cases covered by Hague Conventions. Benefits will accrue within the region and also between the states in the region and outside the region. On the whole, the work of the Hague Conference in the region will certainly raise awareness of issues concerning private international law and provide considerable impetus for change, whether through the means of implementing Hague Conventions or by way of domestic law reform based on contents of Hague Convention. In addition, the progressive harmonization of private international law brought about by the Hague Conference will in turn help to fortify the rule of law on the international level among members and non-members of the Hague Conference within the region. The rule of law, whether on the domestic, regional, or international level, is essential to investment and financial activities as well as economic development. Without putting in place robust domestic and transnational legal infrastructure, including an appropriate framework of private international law, economic factors alone would not be sufficient to sustain the economic growth in the Asia-Pacific region. The Asia-Pacific Regional Office takes its role very seriously. Since its official opening on 13th December last year, the Regional Office has started its outreach by establishing a network with different institutions in the region. Among others, the Regional Office has entered into a Memorandum of Understanding on Academic Cooperation with Kyushu University of Japan. Similar instruments are going to be made with other institutions in the region. The Regional Office also provided support to countries in the region and became a focal point by bringing together countries in the region. On 27th and 28th March 2013, the Regional Office, jointly with the Hong Kong government and the Macau government, successfully organized a workshop on the 1993 Hague Inter-Country Adoption Convention, which was attended by around 40 participants from 6 countries in the region, as well as international organizations. The Regional Office will further its outreach by providing support to the APEC workshop on simplified authentication process for production of public documents abroad through the use of the Hague Apostille Convention in Indonesia in late June this year. The Regional Office is also planning other seminars and meetings. One of them is the plan to organize a seminar jointly with the Asian Society of Notaries Public after its inauguration later this year. Apart from exploring the feasibility of arranging meetings for experts or working groups in Hong Kong, the Regional Office stands ready to provide full support for the preparation of the 5th Asia-Pacific Regional Conference to be held in the near future. At the same time, the Regional Office is actively looking for ways to strengthen the network with the national organs, central and competent authorities in the region, and to provide technical assistance to them as appropriate, as well as to enhance contacts with other officials, professional bodies, and academic institutions in the region. Ladies and gentlemen, the process of globalization, regional integration, and technological advances will continue. States are becoming more and more interdependent, and there are bound to be even more interaction between people from different jurisdictions. The need to have a coordinated or harmonized framework of private international law becomes even more important. In his speech delivered at his first meeting held in 1893, Mr. Tobias Asser, the great Dutch scholar and one of the key founders, described the commencement of the Hague Conference as a dream of his youth that has just started on the road to realization. For the well-being of our global human society, this dream must continue. On this happy and memorable occasion of the 120th anniversary of the Hague Conference, may I wish the Hague Conference, its permanent bureau, its Latin American regional office, and the Asia-Pacific regional office, every success in the noble task of harmonization of private international law in the many more years to come. Thank you very much.
Thank you very much, Your Excellency, for these ideas and reflections. As you will note on the program that all of you have in your hands, we will now break for coffee or tea for about 10 to 15 minutes, and then continue with a panel discussion where the future of the Hague Conference will be reflected by distinguished panelists and the moderator, Peter Trubov. And then on at 5 p.m. we will have a questions and answers session with the Secretary General of the Hague Conference, that is Mr. Hans van Loon. But now we will break for, I would tend to say more likely to be a 10 than 15-minute break, but once you hear the bell tone, which you will not see here, but you will hear outside, please come back and we will continue with the panel discussion. The tea and the coffee are served outside in the lobby, so please served.
Good afternoon. It is a distinct honor and a personal privilege to be able to moderate this panel titled Reflections on the Hague Conference at 140, 20 years forward. So 20 years from today's 120th anniversary. In particular, we will focus on the work of the conference relating to the three pillars of its activities: family law, legal cooperation, and commercial law. As you can see from our program, we have an outstanding panel of senior officials from other international organizations to address this subject. They will speak in a little different order from what you have in your program. My role is to keep matters moving smoothly and to incite our panelists to a productive discussion among themselves after their initial remarks. I also promise that we'll try to reserve some time for questions from the audience to our distinguished panelists. To allow that schedule, our panelists have each pledged to speak initially for 10 minutes maximum, and they've asked me to be strict about it. When they've all spoken, they'll raise questions among themselves and have an exchange of thoughts about the ideas they have presented. We'll then turn to the audience. Our goal is to identify during this panel specific proposals for collaboration by the conference with the organizations represented here today. Given our limited time together, each of our panelists has graciously agreed that I should offer only short biographical information with emphasis on present responsibilities and prior experience that bears on the subject matter today. It would take all of our time to recount the educational training and accomplishments of this panel. For your cooperation, panelists, I'm most grateful. Before the first introduction, if you'll permit me a very short story that I hope will inspire us today. 2 years after his graduation in mathematics from King's College, Cambridge, Alan Turing, then 26 years old, published an article in 1936 in the Proceedings of the London Mathematical Society. That article described generally what has come to be called the Turing machine, not an actual construct, but, if you will, a virtual machine. And the article explained the efficiencies of such a machine. Mathematicians will argue about whether Turing covered everything or got it all right, but this much we can say with the benefit of hindsight. In the one publication by this young man, there was described many of the key elements of today's digital age. The overall design and operation of computers, the uses of software programs, and the development of algorithms. 77 years later, after that article, it holds up rather well as an astonishing look into the future. I don't know whether we'll do as well as Alan Turing did in his time in describing the future of private international law today, or the role of the Hague Conference. We'll certainly try to peer at least 20 years into the future and to predict, even advocate, specific collaborative programs with the Hague Conference by each of the organizations represented here. And now our first speaker, Ms. Suzanne Bissell. Ms. Bissell is Chief of Child Protection at the United Nations Children's Fund, UNICEF, a position she's held since 2009. Ms. Bissell's current appointment is the culmination of decades of successful completion of many challenging assignments to protect the rights and well-being of children. Today, with programs in 170 countries, her office directs a team of professionals dedicated to, among other matters, assisting children affected by armed conflict and strengthening systems designed to prevent violence against children. Ms. Bissell, thank you for being here today, and I'd like to invite you to the podium.
Thank you, Peter. Good afternoon, everyone. Excellencies, Mr. Secretary General, ladies and gentlemen, colleagues, I'm delighted and honored to be back in the Netherlands, and thank you for inviting UNICEF to be part of this panel today, celebrating 120 years of the Hague Conference on International Private Law. My colleagues in New York have asked me to say many happy returns. Both you, the Hague Conference, and we, UNICEF, have among our aspirations that of protecting children throughout the world. And while we cannot protect them from everything, we can and must protect them from violence, exploitation, and abuse. Who are the children we're protecting? They are the 220 million under the age of 5 who live in the developing world right now who do not have birth certificates. They are the 150 million children in the world who are engaged in the worst forms of child labor. The 1 billion children living in countries and territories affected by war. The thousands of children who languish in institutions the world over. And they are also the children living in the 14 countries that are listed by the Security Council for committing grave violations against children, such as recruitment, killing, and maiming. These high numbers are numbers that we would like to see reach zero, perhaps during the next 20 years of our collaboration with the Hague Conference. There's an underlying moral rationale for this, a rights imperative, and a sound economic argument. While protecting children is already a big task when children live in homes and communities, it is an even bigger, and I would argue growing challenge when children are on the move. Today we see children who move with both parents, with one parent, mobile on their own at any age, I hasten to add, alongside a friend or in the hands of a trafficker. Children and families are mobile in response to climate change or conflict, to unite with extended family members, or simply to seek a better life. Mobility in whatever guise can make children particularly vulnerable. And with the increasing numbers of children crossing national state boundaries, protection concerns are becoming increasingly cross-border and require inter-country collaboration. And this is certainly a trend that we envisage well into the future. Although we have different missions and mandates, both UNICEF and the Hague Conference face similar challenges and opportunities in using international law to protect children and to support families. We both must grapple with the difficulties involved in applying international legal standards and instruments to a diverse range of national legal systems. both of our organizations consider not only the focus on the legislation in the country, but also on the application of that legislation. And both organizations persevere in these endeavors despite the many challenges that we face, because we understand the importance of international law, not just at the statutory level, but in everyday lives of people, of families. We understand the 4 Hague Children's Conventions, as well as the Convention on the Rights of the Child, as binding legal documents to which we can hold governments accountable for their obligations to children and families, and that at the most basic level, as fundamental building blocks of a system of laws and standards to protect and support children, especially at times in their lives when they may be especially vulnerable. And it's this intersection of public and private law that we see playing out no more visibly in UNICEF's mandate than in the protection of children. UNICEF recognizes that the importance of the 4 Hague Conventions in bridging gaps between public and private international law lies not just in ensuring that states regulate issues such as intercountry adoption and maintenance, or respond to international abduction and to trafficking in a harmonized and systematized manner. The Hague Conventions also matter because their implementation at state level directly affects implementation of the Convention on the Rights of the Child. This commitment to protecting every child is our greatest common bond, and it is a common bond that I sincerely hope we will still be celebrating when UNICEF reaches its 120th anniversary. Both UNICEF and the Hague Conference know that ratification of a convention and the depositing of official documents do not signal the end of our work, as great as that may be to arrive at that point. UNICEF and the Hague Conference have enjoyed a particularly fruitful collaboration, co-parenting, as it were, the convention's first steps in a country, with UNICEF supporting their operationalization in individual countries and collaborating with the Hague Conference in addressing particular issues. For example, in many countries, UNICEF has taken a role in facilitating missions by the Permanent Bureau to provide technical assistance, invaluable technical assistance, I hasten to add, in implementing the convention requirements. And UNICEF works with the government to ensure the policy and legal integration within the whole child protection system, such as in building the capacity of child protection services. 2 recent missions I just did, one in Cambodia. There, for instance, we have supported 6 Permanent Bureau missions, including one by the Secretary General himself. And in Guatemala, there have been 9 missions of the Permanent Bureau to strengthen that country's adoption system. And of course, we still have much more work to do in Guatemala. We've also worked together on multi-country events, such as regional meetings in Latin America and Southern Africa. This cooperation both allows for awareness raising and identification of training or technical assistance needs in countries yet to contract to the convention. For example, a workshop for Southern and Eastern Africa on all of the child-related Hague Conventions in February 2010 has influenced the decisions of 2 Southern African countries to take steps to join the Intercountry Adoption Convention, namely Angola and Botswana. Other events supported by UNICEF included the 3rd Malta Conference in March 2009 and training for judges in Madagascar in 2010. A representative of the Hague Permanent Bureau also participated in the Francophone Conference on the Alternative Care Guidelines in Senegal in May 2012, and in the Child Protection Systems Conference in New Delhi in November of 2012. Ladies and gentlemen, UNICEF would again like to congratulate the conference on reaching its 120th anniversary. Thank you again for our fruitful collaboration, which we anticipate well into the next 20 years. There's still much to be done at a time when children are increasingly mobile and always precious. It is certainly fair to say that the more countries that contract to the Hague Conventions, the better protected children will be. UNICEF stands ready to collaborate with the Hague Conference in every way possible. As we envisage our future work together, we certainly anticipate paying greater attention to the 1996 Child Protection Convention and its implementation. This will imply capacity building within our own organization, and we'll reach out to you for your expertise and experience in this process. And to conclude, if I may, on a personal note, thanks to you, Hans, and to your team for the warm and collegial relationships we maintain. We look forward to sustaining these, in particular with you as well, Hans, wherever your path takes you next. Thank you very much.
Our next speaker is Benjamin Mesmer. Mr. Mesmer is a member of the United Nations Committee on the Rights of the Child. He's a research fellow and lecturer at the University of Western Cape in Cape Town, South Africa, and he has been the vice chairperson of the African Committee of Experts on the Rights and Welfare of the Child, with special responsibility for addressing concerns with violence against children. Mr. Mesmer, thank you very much, and I give you the podium.
I usually say I'm vertically challenged, so I have to lift. Thank you very much, Mr. Chair. It's a pleasure to be here, to be back here in The Hague, but also in this hall. Good afternoon, honorable guests, excellencies, friends, colleagues, ladies and gentlemen. It's a pleasure to be here. I am the youngest, but probably have the longest indications of my associations in terms of organizations. I will speak in my personal capacity, but also as a member, but I want to say at the outset that whatever I say now does not necessarily represent the views of the organizations that I belong to. First of all, congratulations are in order. Turning 120 is not an easy feat. I would like to thank the organizers for the kind invitation and positive gesture that I have received from their end. Indeed, in a fashion unmistakable in both clarity and intent, this reaffirms the fact that one of the organization's priorities remains children's rights. It also underscores the point that the Hague Conference is indeed a global and multifaceted organization with an ever-increasing interest and impact on the African continent. I only have 10 minutes, so I'll limit my intervention in terms of geography, target group, and also treaty. Namely, I'll try to focus as much as possible on Africa, on children. And while I would have liked to talk about the 4 Hague Children's Conventions, my intervention will predominantly be about the Inter-Country Adoption Convention and maybe a word or two in relation to the 1996 Child Protection Convention. But before I come to my main points, I want to make few preliminary remarks. Africa is increasingly looking inwards to find solutions to its challenges based on African institutions. This is one of the main reasons why collaboration with African institutions for the Hague Conference is inevitable. Secondly, African countries are increasingly trying to learn from each other's countries and regions' experiences, which again makes cooperation with African institutions important. In this respect, the concept of comparability is important. If you want to give an example to an African country, you're better off if you give an example based on experience from another African country, as opposed to trying to draw experiences from other countries in the world. And Africa is not only becoming the new frontier in relation to inter-country adoption. Africa is also increasingly becoming concerned and involved in relation to issues that are covered by the other 3 Hague Children's Conventions. The Hague Conference, and unfortunately the number of African countries that are members of the Hague Conference is very limited. The Hague Conference is aware of some of the obvious reasons why this is the case, and maybe through some sort of cooperation and international support, an aggressive effort can be made to increase such representation. On a related note, the number of state parties to the Hague Children's Convention is increasing with time, and that is very positive. For instance, the last 3 countries out of 5 countries that have ratified the Hague Convention on Inter-Country Adoption are African countries, namely Rwanda, Lesotho, and Swaziland. While I'm on the topic of ratification, the CRC Committee as a treaty body has consistently and systematically recommended to state parties to the CRC to ratify the Hague Convention. It has done this since early 1994, before the Hague Convention on Inter-Country Adoption came into force. In fact, in its recommendations, the CRC Committee's language has partly shifted with time, emphasizing the increasing importance of ratifying the Hague Convention. This shift in emphasis is notable, starting from a statement that says the committee hopes the state party will become the state will become a state party, to the state party ratify, to the committee recommends that the state party speedily ratify, to the last one, which is one of my favorites, which says the committee notes with regret that the state party has still not ratified the Hague Intercountry Adoption Convention. A similar level of lobbying and collaboration is needed not only to sustain this push in relation to the Hague Convention on Intercountry Adoption by the CRC Committee, but also by the African Committee of Experts on the Rights and Welfare of the Child that supervises the implementation of the African Charter on the Rights and Welfare of the Child, but also not only in the context of the Hague Intercountry Adoption, but also in relation to the other 3 Hague Children's Conventions. One of the issues that cooperation helps to minimize is inconsistency. Inconsistency on conceptualization, inconsistency in implementation, and inconsistency in follow-ups. Much clarity is needed in relation to some principles and concepts in the context of intercountry adoption. Therefore, the Hague Conference can strongly cooperate with treaty bodies in proposing and giving concrete input for a general comment on Article 21 of the Convention on the Rights of the Child. I would like to go one step further and say this. In fact, the idea of a general comment on Article 21 of the CRC is not so much an idea whose time has come, as an idea whose time is few years late in coming. In addition, a treaty body is often as strong as its information base. Issues related to the Hague Children's Conventions are not necessarily getting the attention they deserve in the consideration of state party reports by treaty bodies. In this respect, a leaf can be taken from the global initiative to end corporal punishment that regularly submits briefs to the relevant human rights treaty bodies prior to the consideration of a state party report. This has significantly helped in raising the information base of these treaty bodies and contributed to adding clarity to the nature of state party obligations and other stakeholders in relation to the subject matter. It was already alluded this afternoon that the success of the Hague Conference can not only be measured on the basis of member states and the ratification of Hague Conventions, but to a certain extent, on the basis of the extent to which these instruments actually influence domestic legislation. I have a very peculiar example, which is Malawi. In 2005, Malawi had the children's bill that was being drafted, and it had a very interesting provision. That provision said the government of Malawi will not undertake intercountry adoption with countries that are not state parties to the Hague Convention on Intercountry Adoption. The interesting part about this provision was the fact that Malawi itself was not and is still not a member of the Hague Convention on Intercountry Adoption. I can say more words on judicial training, which the Permanent Bureau has done in few occasions, which still has a significant contribution in promoting the Hague Children's Conventions. In the area of intercountry adoption, a number of case laws on the African continent bring to the fore the role of international players, notably the Permanent Bureau, central authorities, foreign adoption agencies, treaty bodies, and the international media. This is because in the absence of a uniform approach, and because legislation in a number of African countries has not been finalized, judge-made law in this region is resulting in inconsistencies and sometimes incoherence in the interpretation and application of the principles and rules governing intercountry adoption. Until such time that the executive branch of government take the lead in this process, the urgent need for regular and concrete judicial training by the Hague Conference for a number of African countries continues to be. Regional seminars and workshops continue to play a significant role to promote the work of the Hague Conference, but also to collectively provide training and support to states likely to share many of the same concerns or obstacles. These events also help to profile the advantages of the Hague Convention, offer a platform for networking and dialogue, and assist in identifying regional and sub-regional challenges and opportunities to improve the cross-border protection of children. Such events can also be seen as capacity-building exercises contributing to the expertise of stakeholders, such as judges, lawyers, on the implementation of the Hague Convention. It also helps to be a stock-taking exercise to identify law reform efforts that are currently existing in draft form in order to embed the principles and underlying tenets of the Hague Conventions that will help to promote children's rights. At this juncture, a word or two is in order in relation to the 1996 Hague Convention. The challenge in relation to the 1993 Convention in a number of African countries is predominantly misconception. For instance, countries feel that if they ratify the Hague Convention, it means opening the floodgates. Or some countries believe that if they ratify the Hague Convention, they might be forced to allow homosexual adoptions. Now, that's in relation to the 1993 Hague Convention. But when you come to the 1996 Hague Convention, it is purely lack of awareness of the existence of this very document. And the 2010 World Cup has actually brought to light quite a number of, I'm just mentioning one single example, has brought to light the number of advantages that the 1996 Convention can bring to the fore. This is again a need to cooperate. There is again a need to cooperate with various institutions, including the treaty bodies, but also the regional economic communities at the Africa level, such as the Economic Community of West African States, the Southern Africa Development Community. I want to spend 1 minute perhaps in relation to talking about international surrogacy. I foresee the need for a more concrete and strong cooperation with various institutions, including the treaty bodies and regional organizations. The issues revolving around international surrogacy are complex and becoming more pressing. Coming up with an agreeable and solid international instrument on international surrogacy will by no means be a walk in the park, and I'm not original in saying this. Rather, it is probably going to be a situation of what I refer to 10% inspiration, 90% perspiration work. The so-called prescriptive and restrictive approaches, a liberal and non-interventionist regime strongly promoted by few but influential countries, issues of international consensus, committee, and so forth will require cooperation and collaboration at the highest level, including from the treaty bodies. And the treaty bodies will have to play a role not only in promoting the ratification of an ultimate document that hopefully will be adopted, but also in the conceptualization and the drafting of such specific documents. 3 more points before I conclude. Maybe 20 years down the line, it might not only be possible but desirable too to establish a practice and system of inter-country adoption that works not on the basis of receiving countries that approach sending countries, but rather a reverse of this model which emphasizes the need of countries of origin and protects them from undue pressure from receiving countries. A system which is practically based on a child-centered approach. More or less a system that I call a don't call me, I will call you system. In addition, with the optional protocol on individual complaints of the Committee on the Rights of the Child coming into force in the foreseeable future, it also opens another avenue for input from the Hague Conference in the work of the CRC Committee. I also note with great interest and appreciation the recent opening of the new Hague Conference Asia Pacific Regional Office in Hong Kong. Some of the proposals that I just mentioned would indeed be facilitated well with the presence of a similar regional office in Africa. To wrap up, the Hague Conference is already undertaking most of these issues mentioned above, though there is room for deepening and widening the efforts. Most of these issues need additional resources. There is a need to be proactive as opposed to being reactive. I don't believe in the saying that the lack of money is the root of all evils. It's my submission that this would be resources well utilized to cover the part of the world with more than 50% of its population below the age of 18. That has a number of challenges, but also opportunities for the application of the Hague Children's Conventions. Excuse me. In this respect, the treaty bodies can and should play a significant role and cooperate with the Hague Conference in bringing this to fruition. Maybe on a lighter note, in 20 years when the Hague Conference celebrates its 140th anniversary, I'm sure I'm not being too optimistic to expect than to hope that we will have one excellency speaking on the impact of the Hague Conference in the Africa region. And I hope to be active and around when that happens. Congratulations in turning 120, but clearly this is not an organization that is counting its days, but making its days count. It is not growing old, but growing up. Thank you very much.
Mr. Mesmer, thank you very much. Our third speaker is Jose Angelo Estrella Faria. Mr. Estrella Faria has served since October 2008 as the Secretary General of the International Institute for the Unification of Private Law, UNIDROIT. Many in this room know Mr. Estrella Faria from his years of effective service as a senior legal officer with the Secretariat of UNCITRAL, the United Nations Commission on International Trade Law in Vienna. He also served for a number of years with the General Legal Division of the UN Office of Legal Affairs in New York. Mr. Estrella Faria has kindly agreed to reflect on the conference's potential collaboration with both UNIDROIT and UNCITRAL. Thank you very much for taking on the dual role.
Thank you very much, Mr. Chairman. Excellencies, dear colleagues, ladies and gentlemen, it is an honor to participate at this high-level panel as we celebrate the 120th anniversary of the Hague Conference on Private International Law. UNIDROIT and the Hague Conference have similar mandates, namely to harmonize and unify the law into distinct but complementary areas: private international law, the Hague Conference, and substantive private law, UNIDROIT. We share a long history of close cooperation, UNIDROIT being second only to the Hague Conference in age among the existing international organizations, which I would not be able to review in the limited time available to this panel. As a matter of fact, this is not what I have been asked to do today. It is befitting of the Hague Conference dynamic and visionary Secretary General, my dear friend Hans van Loon, that we celebrate the conference jubilee not by taking stock of the conference's remarkable record of achievements in its long history, but by looking ahead at its development in the next 20 years. We're all eager to jump back into the future, so I shall be brief. Here's what the crystal ball of a sister organization of the Hague Conference shows me. Raising awareness of legal harmonization work, at least in the commercial law field, and this is the center of attention for the work of UNIDROIT. Legal harmonization work is justified by the belief that legal disparity is an obstacle to trade and investment, and that legal harmonization helps reduce transaction costs. However, the impact of uniform law is not easily quantifiable, which makes it difficult to secure an adequate level of political interest for legal harmonization work. I would hope that by the year 2023, formulating agencies have used their extensive contacts to industry, practitioners, and the academic world to develop a methodology for systematically assessing the economic impact of legal harmonization. The availability of general economic impact studies may be instrumental in removing preconceived ideas that dismiss the harmonization process as if it were a purely academic leisure exercise. This would also help to gain domestic support for specific uniform law projects and expediting practical implementation. My second hope in this context would be that governments and international organizations develop greater awareness of the private law implications of broader topics in the international political agenda. Environment, migration, trade liberalization, food security, child protection, money laundering, you name it. Admittedly, private law is not at the forefront of the debate on any of these issues, and understandably so. But all these phenomena also have private law implications. Greater investment in food production requires a favorable legal framework. International trade demands respect of contracts. Child protection, the enforcement of judgments. Fighting money laundering presupposes transparent corporate structures. The protection of the environment imposes liability for environmental damage. Rule of law begins with constitutional law, political, social, and human rights, but is not complete without individual private rights. Second point, international harmonization and domestic law reform. The classical reading of the mandate given to formulating agencies would limit their activities to harmonizing private law at the international level, rather than helping states modernize their domestic private law. A more constructive and forward-looking interpretation, however, would enable formulating agencies where appropriate to promote the modernization of the law of particular groups of states in need of special assistance. In the same way that awareness of economic impact may strengthen the case for legal unification and harmonization, the consistent integration of economic analysis in the harmonization process where appropriate enhances the role of formulated agencies in promoting domestic law reform. International uniform law instruments elaborated with the expertise and under the auspices of UNIDROIT, the Hague Conference, and UNCITRAL reflect legal standards acceptable to various legal systems and countries at different stages of economic development. They deserve being recognized as solid, unbiased, and transparent indicators of the quality of the law in the areas they cover. I would dare to hope that by the year 2033, bilateral and multilateral donors providing assistance to domestic law reform will have duly acknowledged the advantages in terms of greater legitimacy and acceptability of such instruments as opposed to legislation drafted ad hoc by private sector consultants. Of course, formulating agencies would seldom have expertise in all areas related to the practical implementation of their text, continues available for addressing all needs of receiving countries. However, this should not in itself be an obstacle to more involvement in law reform. The formulation of joint programs or implementation strategies in cooperation with other organizations involved in rulemaking or law reform in a given area might allow for the development of a common approach to the implementation of specific standards or instruments, obviously suitably adapted to the context. The input of formulating agencies might be limited to general advice on the elements of such an approach, or might, subject to availability of resources, which are chronically low in our area, extend to greater involvement in specific projects. At the very least, the Secretariat of a formulating agency has a role to play as a clearinghouse of information to know who the specialists are in particular fields of the law. This brings me to my last point, and that is cooperation in the implementation and application of international standards. An international law instrument is of little value if it is not implemented in practice and if it's not correctly applied. Deficient domestic institutional design, poor regulatory machinery, insufficient resources, and lack of training, among others, are known for frustrating the objectives of law reform. In other areas, uniform law instruments may be incorrectly applied or may even be avoided due to lack of knowledge by judges and practitioners. The Hague Conference has been a pioneer among the rulemaking organizations in devising tools for proper implementation of Hague instruments. It suffices to mention the framework for cooperation and sharing of information in connection with the child adoption and the child abduction conventions. The focus on the implementation phase should be intensified in the future and should eventually become a regular feature of each international uniform law instrument whenever possible. UNIDROIT itself has experience with the establishment of an operational infrastructure to ensure the practical functioning of an international convention, namely the International Registry for Aircraft Objects under the Cape Town Convention on International Interest in Mobile Equipment. Based in Dublin and managed by a private company selected through international public bidding, the registry works under the supervision of the International Civil Aviation Organization, ICAO. The registry operates exclusively by electronic means, applying the highest standards of data protection and speed of communications, and already counts about 300,000 filings since the entry into force of the convention in 2006. I would hope that by the year 2023, formulating agencies and the organizations that are affected by the work we do have expanded existing mechanisms for disseminating information on the application of uniform texts beyond the various databases and information tools that already exist into a systematic and as much as possible coordinated approach to the application of uniform law instruments. As a matter of fact, drawing on its expertise in the era of judicial cooperation, the Hague Conference could become the leading agency in identifying needs for assistance in connection with the application of uniform law instruments and devising assistance programs beyond the implementation of its own instruments. Additional measures to promote uniform interpretation might include increased support for programs for training judges in the interpretation and application of uniform law. This might take the form of seminars or even a common syllabus or other forms of teaching materials that might be used for training purposes or be incorporated into the curricula of domestic academies or schools dedicated to the training or continuing education of judges. Allow me just to open a parenthesis. One of the most successful conventions in the area of private law is the United Nations Convention on Contracts for International Sale of Goods. Now, one would be surprised to see that more often than not, the convention is avoided rather than applied because parties are simply not aware of the convention. They haven't spent the time, and very often in law school, they have not heard a word about the convention, even in countries that have ratified the convention for more than 20 years now. If you consider that the international community invests an average of not less than $10 million in developing one international convention, it is a remarkable waste of taxpayers' money if these conventions are later on not applied because they're not taught in law schools. Now, cooperation with universities, and in particular with other international organizations with expertise in technical assistance and training for lawyers from developing countries, should be explored with a view to developing joint programs of all organizations involved in private law rulemaking, conceivably standard teaching materials or a teaching plan for uniform law. Ladies and gentlemen, I have exhausted my time, but certainly not the list of what this great organization can still be doing 20 years down the road, and even less so of what the foresight of its Secretary General could have envisaged by then, were he not about to embark in another exciting phase of his life, for which I should like to take this opportunity to wish him the best of luck and happiness. Thank you very much.
Thank you very much. Our next speaker is Rufus Yerxa. Mr. Yerxa is the Deputy Director General of the World Trade Organization, a post to which he was named in 2002. Prior to his service at the WTO, Mr. Yerxa was Deputy United States Trade Representative. In addition to serving in a senior position on the Ways and Means Committee of the U.S. House of Representatives, which of course has important responsibilities for trade law, Mr. Yerxa has practiced law both with a major international law firm, Aiken, Gump, Strauss, Hauser & Feld, and as European and international counsel with Monsanto Company. Mr. Yerxa, we're happy to have you with us, and I'll give you the floor.
Thank you very much, Mr. Secretary General and Peter, organizers of this conference. It gives me great pleasure to be here at your 120th anniversary meeting, and certainly to be asked to be part of such a diverse panel of international officials, international civil servants. You know, we all work in very different areas with very different institutional affiliations, yet the one thing that brings us together, the one common element, is that obviously these are people who are convinced that international cooperation, such as that fostered by regional and multilateral institutions, and by these efforts at creating a better rule of law internationally, are an essential tool for addressing the main challenges facing the global community. In a world now where people and goods and services, as well as money, crosses borders with such rapidity and such ease, the ability of nation states acting independently to deal with the many problems that are the byproduct of this phenomenon of globalization are becoming more and more apparent. The difficulties are becoming more and more apparent. So fostering international cooperation is essential, but it is certainly not an easy task. As a former resident of The Hague, Baruch Spinoza once said, "All excellent things are as difficult as they are rare." And certainly it is rare to find complete success in the areas we work in, but the effort goes on. Now, the Hague Conference and the WTO do not have a long history of working together. I hope this is the beginning of more cooperation and more interaction. We have very different mandates and work in different ways, but in many ways, goals and objectives are the same. The Hague Conference, of course, is promoting the progressive development of common rules of private international law and serving as a forum for developing and implementing treaties and conventions in different fields of private international law, but these apply certainly in a way to promote and facilitate the contractual rights and the abilities of private individuals to work across borders. The WTO, by contrast, is a classic public international law body, an intergovernmental agreement with membership only of governments. Its purpose is to reduce obstacles to trade and promote a level playing field, a rule of law between states, and to serve as a forum for governments to develop and implement rules in areas that include trade in goods, trade in services, intellectual property rights. And although our agreements do not impose obligations on individuals, they impose obligations on states. If you think about it, the activities of both of our institutions are instrumental to the broader goal of promoting trade and investment as a way of contributing to development and to economic growth. You have to ask the question, what good would it be for governments to grant rights to each other for freer commerce if private individuals could not protect those rights in their contractual or private relationships? So the interdependence between what we do in trying to create a broader framework of global rules for trade are certainly the interdependence with the many, many conventions which have been developed through the participation of this organization and of institutions like UNIDROIT is absolutely clear. Now, just back on the WTO, you know, this is a system that's origins go back to 1947, to the original GATT agreement, and then changed to the WTO in 1995 with many of the same agreements being carried forward. So for more than 60 years, it has been successful in reducing many of the border obstacles to trade and in liberating trade as a factor in promoting economic growth over the last half century and lifting literally millions of people out of poverty. But it's clear that there is much, much, much further to go and more to do in terms of creating a fairer international trading system, particularly focusing on, for example, improving the rights of least developed and developing countries in the trading system, and also in finding other areas not yet covered by our rules, many of which would, I think, create new opportunities for you here in the Hague Conference, because they definitely would create more transactions across borders and therefore more need to protect private rights. Let me just give you one area that is certainly something we've been working on recently, an example where certainly the creation of a better rule of law in international transactions would be a significant contribution to development and economic growth. And that is the recent work on creating a WTO agreement on trade facilitation. This is a sort of a technical term, but trade facilitation covers many of the areas related to the processing and clearance of goods across borders. The reduction of formalities and documentation requirements for importing, exporting, for transiting goods from landlocked countries to countries with ports, for the establishment of things like a single window for traders to submit documentation and data to government officials in order to carry out their trading transactions, the possibility of electronic submission to allow pre-clearance of goods and those kinds of things, the strengthening of cooperation between customs and border agencies of our member countries to eliminate consular transaction requirements in connection with the importation of goods. One reliable estimate of the costs of complying with these kinds of formalities and procedures and paperwork associated with border delays has concluded that they constitute today roughly 10% of the value of any trade transaction. And if you take total world trade, this puts the cost of these kinds of transaction costs at about $2 trillion annually on a global basis, which is equivalent to almost double the current average of the tariffs imposed by governments on trade in goods. So an agreement in this area with fewer formalities, less paperwork, less red tape, would not only speed up transactions, but would also enable consumers all over the world to benefit from the lower costs. Of course, this also means that the framework of private rights, the framework of conventions and agreements to ensure the enforceability of contracts and the rule of law in private transactions becomes even more important. I think this is one area, obviously, where we can begin to work together. My main message today, however, is since we are such very different organizations with such very different history, the beginning of cooperation and better communication between us, I think, would be a very significant thing, and I'm certainly committed to helping to promote that in the future. I want to thank you for inviting me today, and I certainly look forward to the rest of the conference. Thank you.
Thank you very much, including the research on Spinoza. Impressive. Our final speaker is Ms. Anne-Marie Leroy. Ms. Leroy is the Senior Vice President and General Counsel of the World Bank Group, a position to which she was appointed in 2009. She was, in fact, returning to the bank, where she'd been a senior public sector specialist in the 1990s, working on public management issues in North Africa. Ms. Leroy came back to the World Bank from private practice with the Paris office of Denton, Wild and Sapp. Before entering private practice, she'd served as a senior advisor to Prime Minister Jospin and as a judge at the French Conseil d'Etat. Ms. Leroy, we're grateful for your agreeing to be with us today. The floor is yours.
Thank you very much, ladies and gentlemen. Secretary General, good afternoon, and thank you for inviting me to join you today to celebrate the 120th anniversary of the Hague Conference on Private International Law. The organization's long history and its broad membership and the important multilateral legal instruments on private international law that it has developed are proof of the significant role that the Hague Conference has played in contributing to increased legal certainty in matters involving multiple jurisdictions. The World Bank is a very different organization with a very different mandate. And yet, I do believe that there are areas where we can help each other, and I will go to that later on. The World Bank is a an economic development organization. This is our mandate. Our overarching mission is to eradicate poverty through economic growth. It's a very large organization. Now we have, and our membership is almost universal. And it's a very large organization of almost 15,000 people. I will get back to that because reaching out to the World Bank for the Hague Conference is not necessarily easy. But still, because we promote economic growth for decades now, the World Bank has promoted and continues to promote law as an important dimension of sustainable and equitable economic growth, including in connection with the facilitation of commerce across borders. Let me quote here, because I cannot make any speech without quoting my predecessor, Ibrahim Shihata, former General Counsel of the World Bank, who said once, "The rule of law creates certainty and predictability. It leads to lower transaction costs, greater access to capital, and the establishment of level playing fields." Private international law, in particular, contributes to the removal of legal obstacles and the creation of cross-border private law relations and transactions. Private international law balances international consensus with domestic recognition and also balances the actions of sovereigns and of private actors. Private international law principles and rules help to improve commercial certainty by providing clear channels to increase investment and facilitate the development of international trade. As you know, the World Bank has given considerable attention to strengthening the legal enabling environment, both within nations and internationally, to facilitate the growth of equitable and inclusive private sector-led, and to facilitate the flow of goods, services, and capital across borders. Private international law is a helpful means to that end. For example, studies conducted by the bank have noted the positive effect of the Apostille Convention on the ability of foreign investors to start businesses in those countries that are parties to it. The convention has greatly simplified the authentication of public documents to be used abroad by dispensing with a cumbersome legalization process and replacing it with a single authentication certificate from an authority in the state where the document was executed. Through its numerous conventions, the Hague Conference is creating, in fact, public goods that provide uniform solutions to complex problems faced by many countries, despite their differences in legal systems. Its influence cannot be measured solely by the number of states that have formally adopted these conventions. Many countries also often use these conventions as models, borrowing all or some of the rules therein and incorporating them into their domestic laws. In recent years, our member countries have seen the critical role of the World Bank as residing not only in its provision of long-term financing for development, but in the knowledge and know-how that the bank is able to help convene and harness to enhance development efforts. We aspire to be a solutions bank for development, and the critical part of that depends on the power of shared knowledge. With its global reach, the bank is ideally positioned to connect and convene stakeholders from around the world in order to facilitate knowledge exchange across international boundaries. In today's world, knowledge does not only flow from north to south, but the reverse is also true, as are south-south exchanges. President Kim recently noted that knowledge now flows, I'm quoting here, from entrepreneurs in Delhi to citizens in rural Mexico to civil society in Lagos to policy makers in Sarajevo. The legal vice presidency in this vein has launched a couple of years ago the Global Forum on Law, Justice and Development, which facilitates the knowledge exchange goal. The Global Forum is pioneering a transformative agenda for a global discourse that includes law, justice, and equity in the new paradigm of economic development that is both sustainable and equitable. The Global Forum offers the potential to harness an enormous coalition of intellectual partners across continents and disciplines into a platform for knowledge sharing and dissemination for the purpose of aiding policymakers in improving development outcomes. To date, 126 partners from international organizations, international financial institutions, civil society organizations, the judiciary, central banks, and foundations have joined the Global Forum. The Hague Conference itself has joined this initiative a year ago, 13 months ago actually, and the bank welcomes the inclusion of more partners to utilize this platform to the fullest extent. Last year, for instance, the Hague Conference participated in the Law, Justice and Development Week 2012, where the Global Forum was launched officially, and specifically the conference participated in the session on how to work together, international organizations, and the development of the law of secure transactions. In that session, representatives from the Hague Conference, ANCITROL and UNIDROIT discussed the work of their organizations, their text on secure transactions, and approaches to integrate the work of their organizations into the development dialogue. At the core of the Global Forum are its thematic working groups, which cover several areas. There are working groups dealing with justice and rule of law, law and the economy, environmental and natural resources law, governance and anti-corruption, and empowerment and equity for diverse communities. The working groups are divided into subgroups that are led by intellectual partners who are accountable for managing each subgroup and for its knowledge outputs. The forum can provide the Hague Conference an opportunity to make an invaluable intellectual contribution by participating in these working groups and taking the lead on private international law issues. In fact, the forum can be a way for the Hague Conference to make it to increase the awareness of its conventions, as well as to exchange on the content of the convention and on further cooperation with other organizations that are part of the forum. And it is also possible for the Hague Convention, as well as for other partners, to promote the creation of new working groups or new subgroups that are of specific interest to the activities of the Hague Convention in Citoyen and UNIDROIT. And that is an area where we can work together very much. As several participants have already said, it is necessary now for the Hague Conference to further increase awareness, especially in the continents where this awareness is still lagging, namely Africa and Southeast Asia. These are all client countries of the World Bank. And so beyond even the Global Forum, I would encourage the Hague Conference to continue to reach out to the bank, and the legal department is certainly committed to helping you to do this. As I said, it's a very complex matrix organization of almost 15,000 people. Not all people working on legal development and helping countries develop their private sector law are with the legal department, far from that actually. In the matrix organizations, there are at least 2 other networks where you can find people working on legal development. The Finance and Private Sector Development Network primarily, but also the Poverty Reduction and Economic Management Network. And I could also mention the advisory services of our sister organization, the International Finance Corporation. We know all of them, but it's hard actually, and it takes work to reach all of them. But if you increase awareness of these people on the power of the conventions to help private sector development, to help attract foreign investors to our client countries, they will in turn be your best advocates in those client countries. And the legal department of the World Bank is clearly ready and committed to helping you do that if you wish so. So with this, let me congratulate you again on this 120th anniversary and wish you all the best for the future. Thank you.
I want to thank each of our speakers. It's not easy to say as much as they have each said in 10 minutes, and they've been terrific in staying to that limitation. I've been busily scribbling away in an effort to try to bring what we've had said this afternoon together in a way that would allow a discussion. It seems to me you could take all of what's been said in different ways, but I might put it under 3 different headings: the problems that have been described and the opportunities that have been described. One broad heading would be adherence, just joining the conventions of the different groups that have been described here today. The second heading I would call implementation, or system strengthening, which goes to techniques for effective compliance, and we can all think of things that have been said that fall into that category. And the third one would be new subjects for initiatives, some of which might be substantive documents, some of which might be the kind of perception of the utility of what already exists in various quarters. Having tried to sort of categorize all we've said and the differences that we have, Do any of the speakers listening to the others have any thoughts that they might advance, or should we ask the audience to tell us what we have not covered? Ask the audience. All right. Questions from the audience on what we might clarify in what has been said? Don't all raise your hands at once. Okay. You know this famous press conference that President de Gaulle had where the press had all agreed not to ask a question, and during Algeria, and towards the end of the conference the question hadn't come up and they weren't going to ask it, and so he leaned forward and said, "Il me semble quelqu'un m'a posé une question," and he then responded to the question that he wanted asked even if they weren't going to ask it. So I will ask you each to finish up, because we are on a tight time schedule as well. We're having heard all that you've heard today. You think the conference can make its greatest contribution? Put another way, is it in new programs? Is it in awareness of effectiveness? Is it in the use of techniques, electronic and otherwise? In other words, if you were tomorrow morning going to start working with some element of the conference, where would you start? And I think that might be a good way to kind of wrap up our discussion, because we are running close to 5, and I know I don't want to take away from the interview. But what would you like to do Monday morning as opposed to over the next 5 or 10 years, which many of you have described? Let me see who wants to start on that one. Rufus, you're smiling. Maybe you're willing to do it.
Well, I don't really know where to start. I mean, you know, I think one thing that all of us sense is how much the world is changing and how rapidly it's changing in terms of not just the problems we face, but also the kinds of governance structures that we have to deal with. I mean, in many ways, it's an exciting time that clearly is seeing a rise to prominence of more and more groups, nations that have sort of been underrepresented in the nation-state system. You know, the end of the sort of bipolar world we lived in for a long time has brought about a tremendous change, both in terms of economic activity, but also in terms of differing perspectives on what kind of governance structures to adopt and what kind of what does the rule of law mean. And I think this is really obviously an area that I think needs to be focused on by all institutions. I know that mine has gone through a fundamental transformation. I worked in a negotiation where really the U.S. and the European influence was so great that others had no choice but to sort of eventually reconcile themselves to that kind of leadership. Now it's very much more a shared model. So it seems to me, I hope I'm not being too scattered in my thinking here, but one of the things to focus on is how in that evolving environment, how does that change the work of all of our organizations, and how can we respond most effectively to a much more shared model of not just governance, but of what kinds of principles then contribute to the rule of law.
Okay, thank you. I'm going to go down the panel, starting as I did with you. I might also say that the organization that did the Apostille Convention, the Legalization Convention, might well have something to contribute to the reduction of documentation that you described as being a 10% saving for each of us on our products. I like that idea. Ben?
Thank you very much. The question is Monday morning. I don't want to approach it in a very light note, saying I will start fundraising. But I've already said that quite a number of the issues are not necessarily about financial resources. So the point that I want to make is that Monday morning, maybe to drill the point that a Hague Conference on private international law without Africa, in fact, without the majority of African countries on board, might not necessarily be an ideal Hague Conference, a world organization that is working on cross-border cooperation. I've already made the point that Africa is the new frontier, not only in terms of inter-country adoption, but also a number of other issues related to the other three Hague Conventions. So identifying Africa as one of the main priorities as we move forward might be the point that I want to propose on Monday morning. Thank you.
Thank you. I must say your point about regionalization sharing seemed to me to be one that could be equally applicable in Latin America or other parts of the world. And the idea that sharing is not just global, that there is something in talking to people who know each other and are close to each other is a very good one. And I'm glad you made that. Anne-Marie?
I would agree with Mr. Mesmer. I think on Monday morning, I would focus on the countries that are presently growing very rapidly. And there are several of them in Africa that, I mean, press has, there have been several publications recently about countries that are rising very, very rapidly now in international trade and very rapid growth. I'm mentioning Kenya, Nigeria, Rwanda, Kenya, Ghana, a couple of others. I would focus on these, maybe using the example of South Africa. I understand South Africa is a member of the Hague Conference. And, but of course, Southeast Asia is also important, but I would focus on Africa because this is definitely, when you look at the map of the member countries, that huge continent is very, very missing. Now, you asked, I think, a question about what means to use electronic, etc. Unfortunately, I don't think that anything at present replaces personal contact, training in the countries, especially because we're talking here of countries that often don't have 24-hour power coverage. Where internet is either absent or very slow. So if you count on the internet to reach out to those countries, your progress may be actually very slow. So I would still think of organizing regional conferences, of traveling and meeting them. One reason why our 15,000 people are so hard to reach is that they're constantly traveling. And the reason why they're traveling is that you still can't work efficiently from a distance. You need to meet people.
Yeah, there's a place for the hardcover book still. Susan Bissell?
In terms of financial capacity, it does have an impact.
Oh, absolutely. And in fact, the Hague Academy, which meets in this building, has continued to publish in hardcover for the very reasons that you articulate about the electronic resources. Susan?
I have something for Monday, something for Wednesday, and something for Friday. I think it's sort of a happy coincidence that when you ask the question about Monday, that somebody from The Hague should be on a plane and traveling to Bangkok for the first ever global summit with WHO and UNICEF on civil registration and birth registration. So my point really being The Hague becoming a strong advocate for civil registration and in particular birth registration as it relates to the relevant conventions and child protection. So for Wednesday, I think that there's no area, the provision of technical assistance or capacity building where we've seen such efficacy in the field, and I say that from a UNICEF perspective. So greater provision of technical assistance in countries where either they are signatories or are planning to be signatories, again, in my own field, relevant to child protection. And the third thing for Friday, and we've already started talking about it this morning, is deepening, you're helping us deepen our understanding and our ability to grapple with the 1996 convention. I think if we're to look at trends and where we ought to be positioning ourselves, it's there, and I think that the expertise lies here. So I think we have a busy week next week and months ahead.
That's good. And Angelo?
Thank you. I also divided my thoughts into 3 topics, not necessarily Monday, Tuesday, Wednesday. Probably everything can be done should start on Monday, and probably they were stuck in there on the Friday of the 12th month or 12th year after that. But there are 3 layers, I think, of concern and activity. But I think that's something more can and should be done, not necessarily only by the Hague Conference, and actually the Hague Conference itself would not achieve the improvement of the current situation by itself. And one level I would call consolidating and systematizing, and here I mean instruments that are out there. I doubt that anyone in this room can tell me how many private law instruments exist in the world, produced by the Hague Conference, UNCITRAL, UNIDROIT, the European Union, and then you name it. I don't think that anyone really knows all of them. To how much overlap exists there and how much loopholes exist between them. And why is it that some are a success? Why is it that others are less of a success? And I think there is an immense work to be done there in terms of making the international community and legal practitioners understand what is out there, making governments understand what they have already done, and why is it that work done here was more successful than work done there. And this also has another dimension, and that relates to what you're just saying. You gave an example of one layer of concern, and that is the protection of the child, and then you realize, but there is a private law aspect here. Now, how many other instruments around there in the world have that kind of applications and are just waiting for someone to realize it and then invite these organizations to bring their expertise to the table to help the organizations fulfill their mandate. Just give one example. We are now at UNIDROIT in Rome cooperating with the FAO on private law aspects of agriculture and investment as a supplement to their work on food security. Second topic, coordination, rationalization between institutions. It has a little bit to do with what I mentioned before, but it goes a little bit beyond that. The international community of international organizations consists of a plethora of entities that have a varying number of shareholders, but eventually the shareholders are all the same. And we're all in the business of spending taxpayers' money. Some organizations are better endowed than other organizations that have less resources, but none of this is coordinated in a rational fashion. And I think the day should come for organizations to discuss their work programs together and issue some sort of a better way of spending money and avoiding duplication, but also in complementing each other. How many international conventions will cover one particular topic and then have one provision on private international law? And then we draft another convention on another contract and we add another provision of private international law. And so you multiply and duplicate instruments. And the last point is cooperation and assistance. And here I mean individual states and also individuals. The Hague Conference has been pioneer on that. And I think it's a path that should proceed, and is one that's the only way of really ensuring that the investment made in producing international instruments bears fruit. And that is providing technical assistance and going out, reaching out in the world for the promotion of tax. And there, I think, again, there's a lot that needs still to be done to show to the world in a combined way what we have done. Ms. Leroy mentioned the session during the Law, Justice, Development Week last year when the 3 organizations, Hague Conference, UNCITRAL, and UNIDROIT, presented together their work on secure transactions. We have produced a joint publication. Now, there are much more that we have done so far where the links between the various instruments are not yet sufficiently clear, and we should do more into explaining that. Thank you.
Thank you. And if you'll join me in thanking the panel for a both constructive, informative, and very interesting discussion. Thank you for coming all this way and for celebrating the conference.
Well, Excellences, Mesdames et Messieurs, chers amis, bonsoir. On vient maintenant à la dernière partie de cette réunion d'aujourd'hui, visant à célébrer et commémorer le 120e anniversaire de la conférence de droit international privé, la plus ancienne des institutions juridiques de internationales de la Haye, et dont, je dirais, le premier contributeur, si l'on veut, à la renommée de la Haye en tant que capitale mondiale du droit et de la justice. Nous avons ici un protagoniste de la conférence, le secrétaire général Hans van Loon. Les collègues de Hans au bureau permanent ont bien voulu me demander de l'interviewer ce soir. Et en tant qu'ancien ami de la conférence, depuis presque un demi-siècle, et ami de Hans lui-même personnellement, c'est un grand plaisir pour moi et en même temps un grand honneur de le faire. Et je tiens donc d'abord à remercier les collègues qui ont voulu m'inviter. Mais je dois vous prévenir, je ne suis ni un journaliste, ni un présentateur de télé. Et je ne connais pas le métier, donc. Mais comme le dit Don Juan au commandeur dans l'opéra, farò quel che potrò. Je ferai mon mieux pour accomplir cette tâche. I don't have to spend many words to introduce to you Hans van Loon. These previous speakers have, almost all of them, said some words of congratulations about him. He has been with the Permanent Bureau for a long time, 35 years, if I'm correct. And half of the time he has been the Secretary General, from 96 onwards. Let me recall that the conference has been having a permanent secretariat only for roughly half of its life, since 1955, when the Permanent Bureau was set up under the statute, following the trend after the Second World War to rely not only on cooperation between states, but to organize such cooperation through permanent structures. And since 1955, the conference has had 3 Secretary Generals who served for more or less equivalent time, more or less, some years more, some years less. You have Matthijs van Hoogstraten, George Droos, and Hans van Loon. But Hans was a member of the Permanent Bureau for much longer than his term as a Secretary General. So he was there also during, I think, all the previous mandate of the previous Secretary General. And he has been a direct witness of the developments in the conference and of the challenges that these developments implied. Among them, the most evident challenge, but also the most complex one probably, has been the growth of the conference. From a small organization, essentially an organization of European states, into a more global organization. And this has been a major change in the life of the conference, as it had been in the previous part of its life before the adoption of the statute in 1951. I wish just to give an impression of this, I want to recall that the statute was adopted in 1951 by 16 states, only 16 states, the only extra-European state being Japan. And that 20 years later, or in 1971, there was the year of my first presence in a special commission. Last before your time, Hans.
Before my time, yeah.
We were 14 delegates around the table in the then new premises of the conference in Javestraat. However, if we look now at the beginning of this century, it was the number of delegates has grown so much that it was difficult to accommodate them in the academy conference room that was able to receive almost 300 students, however. So it was a massive, huge development. Now, my first question, Hans, is the following. Which were the challenges that the conference had to face to deal with this transformation into a global nation? Has the increase of interest, of world interest in the conference, been just a reflection of the globalization of international life, or was it due to the policies, to new policies of the conference as compared with the past?
Thank you, Fausto. Thank you very much, and thank you, first of all, for doing me the honor of interviewing or grilling me. I'm very honored that you accepted to do that. Yes, there has been quite an impressive growth these last years. But let me start perhaps by illustrating a little bit from where we came. You've already given some figures. When I joined the Hague Conference in '78, we had 29 members and a few handfuls of states that were parties to conventions. When I took over from Georges Droz, that had grown to 43, and about 40 states that were parties to conventions without being members. And the situation at the time was still that the totality was geographically very limited. We had the appearance, despite all the efforts, of being a very Europe-centered organization and almost a closed club. Just to give an illustration, I was sent by my predecessor, Georges Droz, to New Delhi in the beginning of the 80s to assist the Asian African Legal Consultative Organization with the drafting of a bilateral model agreement on service and evidence. And of course, I was quite happy and honored to do that. But in our mind, we had the idea, why not tell them just to join the Service and Evidence Convention? Beautiful conventions would work for them. And I tried that on them, and the answer was, you know, it's great work that you're doing in The Hague, but this is a different region. You cannot expect instruments worked out in far Europe to be useful here. Now, if you look at the status today of ratifications of the Hague Convention, you will see that India and many other countries in Asia, and it's beginning in Africa, have joined these two conventions. And that is a source of enormous satisfaction for me. So we had to work hard to overcome the image of being a European club, and went actively to seek new members, pushed in part by the fact that the European Union, among itself, took it on it to start legislating in the field. Now, what have been the challenges? If you look at the member states that we have been honored to welcome, and the states that have joined the Hague Convention, you will see that they come from all different groups. They're countries from the common law, they're countries with the continental law tradition, they're countries with a religious background. And yet I don't believe that that was the biggest challenge. If I ask myself and look back at the discussions on new topics, for instance, from the last years, we haven't had many new challenges in that respect. The same questions we had, preferences were already there among the traditional member countries. I think that the biggest challenge for us has been to accommodate very different levels of legal development, often not always linked with different levels of economic development. That has been a great challenge. And if I may give one example of how we dealt with that,
yes.
In our most recent convention on the recovery of child support, where we negotiated with a large number of countries, there's a clear principle of free legal assistance to applications for the recovery of child support. But that went a little far for certain countries which don't have legal assistance in their systems. So we've introduced a second layer where countries can make the delivery of free legal assistance subject to certain conditions. Similarly, there is a system for enforcement that is very strict, and countries that are not so familiar may build in a few more controls.
You see, when I was referring to new policies or old policies, depends if they're really new, it was because I have the impression, maybe it's just an impression, that the conference has tried to shift more and more towards rules of cooperation in lieu of rules tending to unification. Let me be more precise. The statute of the conference says clearly, it's very short, the purpose of the conference. The statute says the purpose of the Hague, I think it's in French, the original, but the purpose of the Hague Conference is to work for the progressive unification of the rules of private international law. So the purpose is unification of private international law. That's in the statute. However, if one looks at the history of the conference, the most successful conventions are those who are not dealing exactly with unification, but are dealing with cooperation. There are some unification aspects, but dealing with cooperation. Look at the Convention on Civil Procedure, for instance. The first successful convention was in 1894. Then it was revised in 1905. Yeah. Then it was the first successful conference, the real cheval de bataille of the conference in 54, with the convention, with the new structure of the conference. Then again it was split into 3 conventions: service, taking of evidence, access to justice subsequently. So it was a successful formula that then was in a way transferred into the Child Adoption Convention. Yeah. That was a cooperation convention instead of a unification convention, really, although there are some unifying aspects. And the same has been taken in the parental responsibility, in the adoption, and later in maintenance. Is this change in being a choice that allowed also to work at this in different layers, as you were saying before?
First of all, I think this is part of a broader development in international law. Wolfgang Friedman wrote a book in the 1960s where he distinguished between the law of coexistence and the law of cooperation. Law of coexistence with emphasis on sovereignty, and that he described a movement towards the law of cooperation, where states work together in, among other things, to make the life of citizens easier. And that is clearly what has also been reflected in the Hague work. We found that simply delimiting jurisdiction of courts, the Adoption Convention is a good example. We had a very nice convention going back to 1965, which was a classical private international law convention with rules on jurisdiction, applicable law, recognition and enforcement. Wonderful conventions ratified by 3 states, among which there were only 1 or 2 adoptions per year. So we had to rethink that and ask ourselves, how come that this is not more widely ratified? It's such an important global phenomenon. And then it appeared very soon that, first of all, we needed to involve these countries. You can not legislate for others, you have to work with them. And second, that the emphasis had to be put much more on mechanisms for communication, cooperation, setting up of machinery that is able to deliver services to citizens. And so instead of abstract private international law rules, we more and more have had to design systems that are directly at the service of our member states, which led to a whole new evolution in our work as a permanent bureau, but also much more engagement and involvement of our member states, who have done a terrific job creating all these authorities, equipping them, and so on. We have now more than 2,500 central authorities and thousands of competent authorities under various conventions. It's really a very, very impressive movement.
You are touching now upon an issue that has been already dealt with in the previous panel to a certain extent, that is the implementation of the convention, which is, I think, a real asset of the conference, to have put the accent not only on the legislation, but work for, if I'm correct, work for unification through implementation, in a way. So having the rules applied. Is that abandoning, to some extent, the role of initiator of legislation?
No, not at all. In my view, certainly not. And most of our work in the non-legislative field is based on
a reaction. I know there was some criticism that was flagged sometimes that the Congress is becoming just an implementation office and not a legislative office.
But the interesting thing about so much of our work is that it is so clearly based on binding cooperative frameworks. There's a firm treaty base, and on that basis we have developed a lot of tools to make it work.
Est-ce qu'on peut aborder un autre défi? On a parlé du défi de la mondialisation de la conférence. Mais de l'autre côté, il y a eu dans le monde, notamment en Europe, mais pas seulement en Europe, une régionalisation progressive du droit international privé. Alors tout spécialement, je prends l'Europe par exemple, 27 États, donc sur les presque 80 qui constituent le membership actuel de la conférence, et bientôt 28, avec l'adhésion de la Croatie, et en perspective d'autres États, se sont donné ces dernières années une discipline uniforme dans presque tous les domaines du droit international privé. Alors, c'est un défi auquel tu as dû faire face durant ton mandat. Parce que ça s'est produit pendant ton mandat, la régionalisation du DIP en Europe date du traité d'Amsterdam, en fait, donc à partir de 99 du siècle dernier. Donc, comment as-tu, est-ce qu'il y a encore une place pour la conférence? Comment as-tu réussi à garder l'autonomie, l'effectivité de la conférence? De nouveau, c'est l'accent sur la mise en œuvre qui a aidé, ou il y a d'autres aspects d'autres instruments que tu as mis en place pour sauvegarder l'autonomie de la conférence vis-à-vis de cette imposante régionalisation d'un groupe important de membres?
Je dirais effectivement que les plus grands défis des deux dernières décennies sont la mondialisation ont été la mondialisation et la régionalisation, la communautarisation du droit international privé. Il y a d'autres facteurs, l'impact direct de la technologie, certaines questions de dialogue interculturel, mais ces deux facteurs ont vraiment caractérisé cette période. Et c'était dur parce que on n'avait pas le bénéfice de pouvoir regarder vers il y avait des incertitudes. Le traité d'Amsterdam avait créé la possibilité pour l'Union, la communauté à l'époque, d'aller légiférer dans le domaine du droit international privé. Et c'était quelque chose de tout à fait nouveau. Et ça nous a posé quelques problèmes. Certaines voix disaient, mais où la conférence du passé, maintenant c'est l'Europe qui va s'occuper du droit international privé, ne vous inquiétez pas, la conférence c'est fini. Heureusement, c'était une minorité, mais c'était quand même une période un peu difficile, mais c'était difficile pour tout le monde. Par exemple, la Commission européenne, qui s'était vue chargée de nouvelles responsabilités, elle avait au sein de la conférence de la Haye uniquement le statut d'observateur. Or, elle devait se prononcer au lieu de au nom de tous les États. Les États membres de l'Union ne savaient pas très bien comment ça devrait se passer. La commission, simple observateur, est-ce qu'on devrait se prononcer pour les autres? Il y avait les États tiers qui se disaient, qu'est-ce qui se passe? À qui avons-nous affaire? À la commission, aux États? Donc c'était difficile. Mais je crois qu'avec beaucoup de sagesse de tout le monde, on a pu faire face aux difficultés. Et ce qui a été très important, évidemment, ça a été que l'Union européenne, la communauté, est devenue membre de la conférence en 2007. Ça a été un grand pas. Et on a ensuite vu, par exemple, une magnifique coopération au sein de l'Union entre Commission, Présidence, États membres et le reste de nos États membres lors des négociations sur la Convention recouvrement d'aliments. Et plus récemment, on a organisé des séminaires ensemble. L'Union s'intéresse beaucoup à la mise en œuvre des conventions, pas seulement à l'intérieur de l'Union, mais aussi dans les relations avec des États tiers, a été très généreux à subventionner des séminaires qu'on a organisés. Donc, je crois que finalement, le bilan est très positif. Mais il est vrai que pour nous tous, c'était une période assez difficile, et surtout que ça coïncidait avec nos travaux en matière de jugement, où il y avait aussi de grandes incertitudes. Et je crois que toujours que l'idée de combiner la session diplomatique sur cette convention sur l'élection de fort et la décision sur l'admission de l'Union européenne a été une décision sage qui a combiné deux dossiers difficiles, et on a pu les résoudre avec succès. Et ce qui est intéressant, je voulais dire ça encore, c'est qu'on a vu des développements similaires, par exemple en ce qui concerne les pays latino-américains qui ont suivi l'exemple des pays européens, se concertent avant les réunions, pendant les réunions, et viennent aussi de plus en plus avec une voix. Et ça peut beaucoup faciliter les négociations. Pas toujours, mais oui.
Donc on peut s'attendre à un futur de la conférence comme coordinateur des régions, peut-être.
Je crois que la force quand même la plus forte est la mondialisation. Oui. Ça a un impact sur nous qui est énorme. Et les différentes régions ont besoin d'une plateforme où elles peuvent s'entendre, elles peuvent coopérer. Oui. Et ça a été pleinement reconnu par l'Union et géré avec beaucoup de sagesse aussi.
Now, Hans, one question which may be easy to answer but not necessarily very easy I want to put to you is the following. I think we all agree in this room that private international law is probably the most complex, the most sophisticated field of law. Something that sometimes each of us has this experience probably in his life, talking to people, even lawyers, to have the reaction that even except specialized lawyers do not understand much of private international law because it's too complicated, it is too abstract also, looks very distant from daily life, actually. Now, and the conference may appear to many as a sort of distant tower, maybe, where a group of specialists spend their time in long debates, sophisticated debates, having no or very little impact on real life, except perhaps for those people who have a standing of life that brings them every day around the world, that have an international life, but this is not the real life of common people. So what have you done in this respect? Or more simply, to put it simply, what has the conference done for common people, actually? And to, in a way, to set aside this perception that might be of a very distant body not having to do with real life.
Yeah, it's funny that discipline
which is the social dimension. I mean, it is
yes,
a social dimension.
Yeah, but discipline has that image. I have got that image, I'm afraid, also at university. And when the job that I had before coming to the conference as a practicing lawyer, I saw these green books in the library, and I didn't feel particularly attracted to them. The man who persuaded me to make the move was Georges Droz, and my predecessor, and he was not only a savant, but he was also a very, very practical man. And in fact, if you look at the history of the Hague Conference, you will see that Tobias Asser himself was, before everything, a practicing lawyer. So there is a long tradition in the Hague Conference of being interested and working for people. I think your question is linked to what we discussed on the change, the movement from emphasis on coexistence to cooperation. When the Hague Conference had did work on the Convention on Protection of Minors in 1961, there was one problem that could not be solved, and that was the abduction of children. One aspect of that was that countries were hesitant to return children of their own nationality to other countries. That had to be overcome. But it was also clear that a pure traditional convention with rules on jurisdiction would not do the job. You needed to provide assistance to parents who needed to locate their child, to find out where the other parent was, to assist them with making applications and so on. So the 1980 Convention on Child Abduction was a real breakthrough by creating a system of administrative cooperation among countries, in addition to the traditional jurisdictional aspects. And on that success, we've built the Adoption Convention and all the other instruments that you have done. And that created the need to do more on providing central authorities with tools, with good practice guides, with practical handbooks, extending also to practicing lawyers. And we have worked hard together and got a lot of response also from professional organizations, from lawyers' organizations, huissiers, they are in the room, and academics.
So professional associations have brought a lot of assistance to the conference in its activity.
Yeah, and I think what I share with my colleagues is deep inside a feeling that there is a basic unity of the human family, and that we are not working for conventions on the books, but want to really see practical results. And our whole working method is based on that. We do empirical research, we look at how can we be useful, we make conventions. If they are not useful, we review them, and we may make new ones.
Yeah, I think this is a very important question, a very important answer you gave. So on this, that the conference is serving the people and not just a few people or a limited number of people. And currently with migration, so this is extremely important. What to do? A last question before giving the floor to the audience. The results of your mandate as Secretary General have been prodigious. I mean, everybody recognizes you and has been recognized even this afternoon. You have done an excellent job, and you can be proud of what you have done. Mais est-ce que tu as des regrets? Est-ce qu'il y a des rêves qui sont restés dans le tiroir? Chacun en a, évidemment. Donc ça serait bizarre que le secrétaire général n'en ait pas. Mais
laisse-moi dire d'abord que beaucoup de mes rêves ont été vérifiés et que je suis très, très, très content et très heureux d'avoir pu les réaliser. Des regrets, il y en a des milliers, évidemment. Des rêves qui ne sont pas concrétisés, oui. Là, je dois être un peu plus grand prudent parce que certains de ces rêves figurent sur l'ordre du jour des jours qui viennent. Et là, le Conseil devrait se prononcer. Mais par exemple,
alors on ne parle pas du rêve commun qu'on a.
Voilà.
Donc, voilà.
Et oui, on a entendu de nouvelles,
pour
de nouveaux rêves qui sont suggérés par le panel. Mais prenons un exemple un peu. J'ai une certaine responsabilité pour le fait que le sujet des jugements a été proposé à la conférence plutôt que dans une relation bilatérale entre les États-Unis et l'Union européenne. Et parfois, je me suis dit, my God, qu'est-ce que j'ai fait parce que c'était difficile. Heureusement, on est arrivé à conclure une convention sur l'élection de Faure, mais le rêve allait au-delà de cela, n'est-ce pas? C'était l'idée de... Et tu as eu un rôle très très important dans cet exercice. Nos rêves allaient au-delà de cela. Je garde l'espoir qu'on trouve les moyens, l'enthousiasme pour aller de l'avant et arriver à un instrument utile pour le monde entier sur la reconnaissance et l'exécution des jugements et peut-être au-delà de cela. Donc là, je serais vraiment très content si on pouvait réaliser cela. Il y a d'autres points. L'accès au droit étranger, j'ai toujours cru que ça pourrait toujours être un sujet intéressant. Je crois que le monde en a besoin, le monde juridique en a besoin. On a une bonne base dans les recherches. On a convoqué des réunions d'experts qui ont donné leur avis de manière très convaincante. Donc, je crois que ça mérite peut-être, pas nécessairement demain, mais être exploré. Je crois aussi que si on prend par exemple la situation des couples non mariés, n'est-ce pas? L'idée de la conférence est que c'est l'idée du pluralisme juridique. On accepte qu'un juge d'un autre pays, en appliquant sa loi, arrive à une autre solution que nous. Que les systèmes sont différents, mais dans la mesure où deux personnes ont pu légitimement, selon leur loi, entrer dans un partenariat, par exemple, est-ce qu'il ne serait pas normal qu'on reconnaisse cette situation dans d'autres pays, pourvu que cette relation ne perturbe pas l'ordre public du pays de la reconnaissance? Je crois que c'est un sujet qu'il faudrait approfondir.
Mais bon, chacun, évidemment, on ne peut pas... quelquefois, il faut savoir attendre le bon moment pour les projets, oui. Le moment viendra, et on espère pour tous ces projets. Peut-être, à ce stade, je vois que l'heure avance. Est-ce que... moi, j'ai eu la chance de poser une série de questions à Hans, mais est-ce que vous voulez profiter et poser des questions vous-même maintenant? C'est une opportunité unique, donc profitez-en. Any question you want to put to the Secretary General, to Hans van Loon? From the... No questions?
I may have regrets, you may have regrets, so what...
Unless you have a question for them.
What should I have done? What should we do? What should we do more? Where would you like to put the emphasis?
But if you ask ask them to ask where you didn't do enough, there would be no answer, because the answer is that you did prodigiously, you did far more than you could have done during your mandate. So there could be no question in this respect. Oh, please.
Je posais une question en ma qualité de secrétaire général de l'Académie de droit international de La Haye. Parce que je voudrais à cette occasion, enfin nous sommes dans le bâtiment, et je voudrais à cette occasion d'abord dire toute la bonne collaboration que grâce à M. Van Loon nous avons eue avec la conférence. Et je voudrais lui poser une question qui est la suivante. Enfin, est-ce qu'il ne pense pas qu'il y aurait tout de même un très grand intérêt à renforcer encore ces relations? Après tout, nous parlons de projets. nous parlons de ce que sera l'avenir. Et l'avenir, malheureusement pour nous, il n'est pas entre nos mains. Il est entre nos mains de la jeunesse. Et la jeunesse, ce sont les étudiants, ce sont ceux que nous formons dans les universités. On a fait allusion tout à l'heure à des insuffisances dans les facultés. Mais l'Académie, elle, essaie aussi de former ces jeunes, de former les juristes de tous vos pays. Et je pense qu'il faudrait réfléchir à de meilleures articulations, finalement, entre le monde de l'enseignement et de la recherche et le monde de la pratique. Vous avez déjà fait beaucoup, mais je pense qu'il faudrait que l'on continue dans cette voie, et je serais intéressé d'avoir votre sentiment là-dessus.
Ouais, merci beaucoup pour votre question, et je dirais presque que c'est à mon successeur d'y répondre, mais je le connais un peu, et je crois qu'il va vous dire sans réserve, en principe, très très volontiers. Mettons-nous lundi ensemble et on va... oui, surtout, si l'Académie pourrait nous joindre dans nos efforts aussi de travailler à un niveau parfois très proche des gens et très pratique. Hein, parce que ça, c'est évidemment notre mandat, de travailler pour la bonne mise en œuvre de nos instruments. On peut en faire un groupe, on peut combiner des conventions. Donc là, on monte un peu à un niveau plus général peut-être, mais le focus sera toujours sur l'aspect très pratique. Donc, mais évidemment, la théorie et la pratique doivent se rejoindre. Donc, je dirais qu'il y a là un très bel avenir. Mais encore une fois, c'est à Christophe Bernasconi d'explorer cela en premier lieu avec vous. Je serai à 100%, personnellement, 100% intéressé aussi à contribuer à ce dialogue.
Le professeur Daudet, vous-même, vous avez mis l'accent sur un problème essentiel, en fait, parce que the conventions give a lot of opportunities to people and do a lot for people. We discussed that earlier. But it's necessary that people know that there are these opportunities, because sometimes states, if people in the state are not educated, not pushed to have the implementation carried out, governmental authorities may be not aware or reluctant to take engagements and to work on this. So it's education, extremely important education, as the education given by the Academy worldwide is extremely important in this respect and goes to the future, actually, of the implementation, as you say.
Et je voudrais encore remercier M. Daudet, le secrétaire général, pour nous avoir permis, en tant que conférence, d'avoir un slot dans votre programme tous les semestres d'été. Ça a été une joie pour mes collègues et moi, et j'espère aussi utile pour les étudiants.
Any more questions from the audience? Please, don't hesitate. If you have any question, please. There is a micro, probably. Yeah.
Hello, my name is Kate Gibson. I am a legal advisor at the Iran-U.S. Claims Tribunal, so I'm an outsider to this process, and I appreciate your hospitality here, letting me listen in today. I'm coming from another conference which featured a question and answer session between the American and Canadian treaty negotiators, and they were having a debate about whether or not the primary purpose in treaties is to set out the exact obligations that will apply to the countries set in stone at the time of drafting, or whether or not the treaty should be more general processes, set out principles, and then allow the countries to implement them, and allow that implementation to sort of evolve and develop as the needs arise. I was wondering for your thoughts on that question. Thank you.
Thank you very much for that question. Yes. Now, our conventions generally deal with rights and obligations of private citizens, companies, and so on. And they are destined to be applied directly by the judges and authorities in the different countries. So they are self-executing necessarily in order to be useful. So our effort has always been to craft rules that are as precise as possible, as predictable as possible, to give the judges and authorities the greatest chance to apply them consistently. So that may be a little different from other treaties. And of course, to the extent that we create machinery for the implementation of the conventions, the central authorities and so on, there the states have a certain freedom to and the directions are not that strict, but in principle I would say that our efforts should be directed at making it possible for the conventions to be applied at a very local, direct level by the authorities and courts, and that private parties can know what their rights and obligations are, or at least the system of law that applies.
But of course, notwithstanding that, there are always margins for interpretation. And I think the advisory role of the Permanent Bureau in giving the gist of the different conventions in order to have a uniform interpretation is essential.
Yeah,
I don't know how much you are involved, all of you in the Permanent Bureau, on this advisory activity, on how to implement in order to have a harmonized implementation, but I have the impression it's sometimes almost a quasi-judicial activity you are performing.
You're quite right, and of course we do our efforts to make very precise rules, but we do not always achieve, and sometimes there has to be a certain margin. And then there may be difficulties. A good example is the Child Abduction Convention, which is basically a very straightforward, simple instrument, but there is an enormous variety of approaches, unfortunately, to certain articles. Now, we don't have the benefit of interpretation by the International Court of Justice here of our conventions. That's maybe something for the future. There's an old protocol, by the way, of 1931, which provided for that solution, at least competence of the predecessor of the International Court of Justice. So we have to rely on peer review by central authorities. We convene meetings where we special commission review meetings of different countries, states parties, to discuss differences in interpretation. And we provide good practice guides to help promote consistency of interpretation. But basically our starting point, I think, should still be to make rules as precise as possible, because they are directed not to states but to the courts and authorities and individuals that apply them.
Sure. Any more questions? We still have some minutes in case. Please, Toyn.
Heureusement, il y a eu, je l'ai pu constater pendant que j'ai été président de la conférence, que des dizaines de jeunes juristes ont passé au bureau permanent pour une période plus ou moins longue, disons une année ou même une ou deux années, et ont fait d'expérience de la pratique et les problèmes. La pratique et les problèmes qui se posent pour le bureau permanent. Et il est maintenant inconcevable que le bureau permanent serait réduit à 5 ans, disons 5 ou plus 6 ou peut-être plus de grands juristes et de secrétaires très efficaces, mais c'est tout. Il est inconcevable que le travail se réduit. Et grâce à votre inventivité, je dirais qu'il y a pas mal de jeunes juristes qui ont passé de assez longues périodes à la Haye et se sont connus. C'est déjà un aspect de la conférence que je voudrais souligner, parce que c'est pendant la période du secrétariat général d'Hans que
cela s'est produit.
Voilà.
Oui. Thank you very much for this complimentary. Well, please, Hans.
On n'avait pas de choix. Il fallait faire appel on n'avait pas de choix. Il fallait bien faire appel à ces jeunes, si j'ose dire. Et nous devons être énormément reconnaissants à tous ceux qui nous ont aidés, très souvent à leurs propres frais, n'est-ce pas? Ils viennent ici, on ne peut pas les payer ou pas payer beaucoup. Et mais ça a été une aide fantastique et aussi très intéressant pour nous parce qu'on a reçu des gens des pays qui étaient nouveaux pour nous. Oui, ça a été une expérience très enrichissante et j'espère beaucoup qu'on pourra continuer avec ça. Le problème, c'est un peu que dans notre bâtiment actuel, l'espace devient un peu réduit et on doit très souvent refuser des demandes. Et en plus, on n'a pas toujours le staff qui pourrait les accompagner de manière correcte. Donc là, théoriquement, on pourrait faire beaucoup plus encore.
Well, you will need more space, maybe also, but I remember when the conference was in Zeestraat, there were 2-3 rooms. Then in Javastraat became 6 or 7 rooms, 6 maybe. And then the new building now, there are more. And maybe the future will be in a new building or in the next to that building.
And the regional offices may.
And then you have the regional offices as well. So
next one in Africa.
That's exactly the growth of the. Well, we will not go into into what we have to do in the future because the previous panel already told us you have to do this on Monday, this on Tuesday, this on Wednesday. So we know, I mean, Christophe Bernasconi knows exactly what he has to do as of next week on. Maybe this week is still, but until when he'll take over the position of Secretary General. Well, this has been a very interesting conversation. I hope that through this interview, the audience could receive a special insight into the work of the conference, which is a special entity, I think. The conference is a legal organization, of course, but I would say, first of all, is a legal community with members and friends all over the world, which includes delegates, country representatives, experts, academics, private practitioners and others, judges, who work together, if I dare to say, under the same flag, actually, to harmonize private law in the respect for legal differences, with a view to setting aside obstacles that hinder the movement of people in our global world. So in some respect, the conference is giving a true contribution to the global society we are facing now. And I believe that all of us must be extremely grateful to Hans van Loon, first for being here in this conference, in having this interview, but in general for having, as a whole, for having performed a leadership role in this strive towards cooperation. And with him we should associate in our gratitude the members of the Permanent Bureau, Christophe Bernasconi, obviously Philippe Lortie, Marta Pertegas, Louise Ellen Teitz, and all the wonderful team, Toyn has made reference to them, the wonderful team of women and men that cooperate with the Permanent Bureau, in the Permanent Bureau, not only in The Hague. Their commitment, their achievements have been really excellent during these decades. Hans, mon cher, tu as fait un travail magnifique. Chapeau. Well done.
Merci beaucoup. Merci beaucoup, cher Fausto. Et ce que tu as dit est vrai. Et ce qui me manquera le plus, c'est ce miracle d'être parti d'une très grande famille. Mes collègues proches, non seulement les juristes, mais tout le staff qui était extraordinaire, qui reste extraordinaire. Le contact avec les délégués, les experts, les académiques, les autorités centrales, les juristes, les professionnels, ça c'est le côté le plus difficile qui me manquera. Et ça a été un énorme privilège de travailler avec vous tous. Mais il y a encore du travail à faire jusqu'au 1er juillet. Donc, on se reverra encore. Un grand merci à toi, Fausto, pour avoir...
C'était un plaisir. Alors, nous en terminons avec cette entrevue, mais la fête continue. Comme on dit, avant de passer à la réception qu'on aura après, je donne la parole à Christophe Bernasconi, qui a encore quelque chose à dire. Je n'en dis pas le sujet parce que ce sera lui qui le dira.
Merci Fausto. Si je me permets de vous rejoindre au podium à ce moment-ci, c'est d'une part, et je le rassure tout de suite, tendre la main au professeur Dourdet, secrétaire général de l'Académie, et confirmer que nous restons bien évidemment parfaitement intéressés à continuer la collaboration et à l'intensifier. Mais si je vous joins ici, c'est surtout aussi pour annoncer à Hans que c'est le moment où ces célébrations prennent peut-être une tournure un peu plus inattendue pour toi. Je crains que la réception ne devra attendre un peu. 35 ans au sein de l'organisation, au service de l'organisation, dont presque la moitié en tant que secrétaire général. Si je compte bien, Hans, tu as très activement participé à la préparation, l'élaboration de 9 conventions, de la révision d'un statut. Tu as plus que fait doubler le nombre d'États membres de l'organisation, le nombre d'États non membres mais participant aux travaux de la conférence a connu un essor absolument remarquable. Nous avons eu la chance d'ouvrir 2 bureaux régionaux. Tout ça n'est que la face la plus visible des résultats de tes engagements. Mais nous avons pu constater, encore une fois, tout au long de l'entretien avec Fausto, combien tu t'es dévoué et que tu continues à te dévouer pour cette organisation qui te tient tellement à cœur, qui nous tient tant à cœur. Nous tous qui sommes présents ici, et à travers nous, je crois tout le monde, de ceux qui ont bénéficié d'une manière ou d'une autre des travaux de la conférence, nous ne pouvons effectivement que lever notre chapeau et te dire très sincèrement, de tout cœur, un grand merci, Hans. Alors, je dis tout de suite ce que je répète à tout le monde, tu es et tu restes secrétaire général jusqu'à la fin du mois de juin, mais nous avons voulu profiter de la présence des dignitaires, des représentants d'État, d'experts, d'amis, de collègues, pour te faire une petite surprise. Having worked closely with Hans over the years, I know that the job is highly demanding, but at the same time extremely rewarding, not just in terms of the work produced, but also in terms, and in particular in terms of the people encountered along the way. In Hans's case, many of these people have become lifelong friends. This gave us an idea at the Permanent Bureau, an idea that we had to keep secret from you and bring to fruition undercover without you getting suspicious in any way, and while, of course, je rassure les membres, trying at the same time to do all the real work that had to be done. But I think we managed. We have contacted, behind your back, a few people, in fact, quite a few people, And these people have come together as friends, Hans, to offer a book of essays in your honor.
Oh no. Oh no.
A liber amicorum in the fullest, the truest sense of the term. Over the past months, the Permanent Bureau has secretly organized and collected essays from some 56 contributors. A lot of them, I'm very happy to say, are here today. They comprise subject matter experts, delegates designated by various states and international organizations, as well as present and past colleagues from the Permanent Bureau. The contributions, which make up a volume of over 700 pages, offer insights on a wide range of current legal issues, historical accounts, cross-disciplinary perspectives, which aptly reflect your commitment to private international law, which actually is the title of this book. Ce travail en catimini fut certes un travail d'équipe dont je ne suis que le fier et heureux porte-parole. Mais ce travail n'aurait jamais vu le jour sans les talents d'organisation, la patience, la discrétion et la bonne humeur de ton assistante personnelle, Sophie Pinault, qui a magistralement géré et orchestré le tout. Qu'il me soit permis ici, au nom de toutes celles et de tous ceux qui ont été impliqués dans l'organisation et la réalisation de cette petite surprise, de lui dire un grand merci. Avec cela, Hans, il me fait grand plaisir, au nom de tous tes amis du bureau permanent, présents et passés, au nom de tes très nombreux amis qui n'ont pas hésité à se joindre à cette merveilleuse aventure, et aussi au nom qui auraient bien voulu s'associer à l'aventure, mais n'ont pu le faire par manque de temps. Il me fait grand plaisir, au nom de tout ce beau monde, de t'offrir ces mélanges.
Incroyable. Merci beaucoup. C'est la bonne couleur. Oui. Chers amis, je suis sans mots. Je suis vraiment... Je suis sans mots, I'm really speechless. Et surtout, comment avez-vous pu faire ça sans que je puisse le savoir? J'essaie quand même de suivre un peu ce qui se passe au bureau permanent. Je sais que je n'y arrive pas toujours. Mais faire un travail comme ça, rester en correspondance avec tout le monde, rappeler, je sais que c'est incroyable ce travail. Donc je suis vraiment perplexe. Et je ne peux que dire un énorme merci. Thank you so much for... It's more than I can at this moment understand. It touches me deeply. I can't even 56. That's incredible. I can't even realize who are all the participants. Thank you very, very much. Un très grand merci. Et à toi aussi, Christophe. Nous avons très, très bien travaillé ensemble toute la période depuis le début. Je suis énormément fier que tu seras mon successeur, qu'avec tous les défis de ces derniers mois, tu as pu organiser tout cela avec les collègues qui ont aussi subi quand même un peu le stress de la transition. Je trouve ça vraiment incroyable et je suis profondément touché. Un grand merci à tous et à toi en particulier.
Hans, je te prie de t'asseoir une nouvelle fois,
Merci
de
beaucoup.
te remettre un peu de tes émotions, parce que ce n'est pas fini. Je crois savoir qu'il y a une autre surprise qui t'attend, et je ne peux l'apercevoir tout de suite, mais je demanderai à l'ambassadeur Susan Jacobs, si elle est présente, de venir me joindre ici sur le podium.
Assieds-toi alors.
Hans, this is a special surprise because Hillary Clinton could not be here today, but she sent you a letter of congratulations on your retirement that I would like to read to you. Dear Mr. Secretary General, I am delighted to join with your friends and colleagues in extending my congratulations on your retirement as Secretary General of the Hague Conference on Private International Law. I am deeply grateful for your many years of service, your outstanding accomplishments, and in particular, your unwavering and critical support of the United States in its commitment to protecting the rights and welfare of children around the world. Your leadership has made possible the wider acceptance and effective implementation of the Hague Conventions, in particular the Abduction Convention and the Adoption Convention. You have also been a critical partner in the extension and effective operation of the Apostille Service and Evidence Conventions, which are of invaluable assistance in permitting U.S. citizens to pursue claims more effectively in U.S. courts and international fora. Your willingness to bring the resources of the conference's Permanent Bureau to the aid of countries facing challenges in fully implementing these conventions has been of immeasurable value. Indeed, your work has ensured these important instruments of international cooperation will remain secure and vital for generations to come. To honor and celebrate your leadership and contributions, I have authorized the U.S. Department of State to award you a Tribute of Appreciation certificate. We value our continuing partnership with the Hague Conference on Private International Law and its members and extend our best wishes for you to enjoy good health and great happiness in your retirement. With great appreciation and best regards, I am sincerely yours, Hillary Rodham Clinton.
Again, I'm deeply touched. It's too much. I'm immensely grateful. We had hoped, as you say, that Hillary Clinton, Secretary of State, could be with us. We've always felt her support, her interest in our conventions, and you yourself, Susan, you're here because of her, and to a certain extent, isn't it? At some point, the Secretary of State found it necessary to appoint a special person, and who could that be better than Susan Jacobs, to work for the implementation and promotion of the Hague Conventions, in particular on children. So I'm, again, speechless and deeply touched. And I think we now all deserve a drink.